morning, everyone. This is Tammy Smith, Director of Training and Education with the Michigan Chamber of Commerce. I'll be your moderator for today's program. Thank you for joining us. Today, we're pleased to present Managing Unemployment Claims and Costs in the COVID Area, which will run until noon. The webinar is being archived and will be available shortly on demand on the webinar website. We will be taking a break about 10:20. If you need assistance at any time or have questions for the speaker, type your question into the chat box on the lower left side of your screen. We respond as quickly as possible. We also encourage you to download a copy of today's slides from the links box, which is above the chat box, to follow along. And now it's my pleasure to introduce Brian Gimrick, Director of Operations for FAR Management Incorporated.
Thank you, Tammy, and good morning, everybody. I hope everyone can hear me well. Today's webinar is going to be a shortened version of normally a much longer version that I typically give. This is going to be focused primarily on issues related to COVID and in terms of how to respond to claims and issues and problems related to that. One of the things that we are going to do is as we go along in this, if you have questions as I'm speaking, it would be good if you could just type them into the chat box and I'll answer them as we go along. I find that usually a little bit better than to try to answer them all at once at the end kind of a thing. So I'd rather kind of do that. So please feel free to do that. Also, in terms of this particular presentation, I'm going to do about a 10-minute break, and it will be about 10:20, and we'll take a 10-minute break so everyone can get coffee and that sort of thing, and then we'll kind of come up from that point. So, all right. So to begin, my name is Brian Gimrick. I work with a company called FAR Management, and we are a third-party administrator. We manage the unemployment programs for a little over 600 employers throughout the state of Michigan. And we've been doing this since 1987. FAR Management's been doing it since 1987. I've been with FAR since 1994, and I've done a little over 12,000 unemployment hearings and handled the entire process throughout it. So we've been around a while. We also are a member of the chamber and part of the programs that they have as well. And so we've been doing this for a while here. To give you just a kind of brief overview of what we're going to do, part of the first part is I just want to kind of give an explanation of what's going on at the State of Michigan Unemployment Agency. It's really kind of important for everyone to understand the challenges that are going on so that you can understand why things are happening the way they are. Then I'm going to kind of focus a little bit more, just a little bit on issues specifically related to the COVID emergency situation. And then I'm going to go into a little bit about taxing and reimbursing processes. If you're a taxable or a reimbursing employer, you will find that there are different challenges to that, especially as it relates to your paying your bills and stuff. So I really want to kind of focus on that because that could be very important in the upcoming year. And then I'll touch on the claims process and what you're going to be seeing in the charging process as well. If we have time at the end, I'd like to touch a little bit on the hearing process if we have time, and hopefully we'll just a brief little blurb on that as well. To begin with, and I think everyone understands and knows that with the COVID emergency, what originally happened. Right now, in the state of Michigan, over 2.9 million people have already filed for unemployment benefits since March. So you're talking a little bit over 7 months, and 2.9 million people filed for benefits. 3.9 million separate claims. That means 1 million people filed for benefits, went back to work, and then had to refile again or reopen their claim. So there's been a total of over 3.9 million so far that is known. When I say what is known is that the unemployment agency, their tracking mechanisms and systems have been overwhelmed, so even they are having some problems tracking some things about what the actual extent of the problem and their issues are. But you know, it's pretty immense, the challenge. Every claim, and for people to understand, is that every claim that gets filed by the unemployment agency, someone files, the agency has to make separate decisions on things such as certifications, filings, registrations, the actual separation information, and charges regarding to it. Every single claim requires at least 5 separate decisions made by the agency, at least. That's a minimum. And so as a result, you're looking at over 15 million separate decisions that the agency has to make at a minimum since March. As a result, they are absolutely buried. They still are, and they're going to be buried for quite some time. I know anyone who's trying to make phone calls to the agency in March and April almost had no shot at all at getting through to them. They were able to respond to less than 1/10 of 1% of all the calls coming in. According to the agency, and I'm not 100% sure that how accurate this is, but at least according to the agency, they're indicating right now they're still receiving about 175,000 calls a week, and that they are indicating that they're are able to respond to 120,000 of them. Based on what we're hearing from claimants and others, I think that might be a little rosier picture than the reality. There are people that we're talking with that are spending days still trying to get through to them, but at least according to the agency right now, they're getting to about 50–60% of the calls coming in a given day and week. They've also had the issues and challenges of new laws, new programs, executive orders coming and going, and trying to incorporate that into old legacy computer systems it's caused a lot of problems, a lot of things that unexpected issues and challenges that for employers to have to try to deal with. So it's been an enormous problem. When it first originally hit in April, the unemployment agency, unemployment agency is funded actually by the federal government. They're state employees, but it's funded by the federal government. And the funding is based off of how many unemployment claims a state had in the prior year. So when this hit in March, the state of Michigan and other states across the country had the same issue, which is they were probably at the least number of staff members that they have had in many, many years. And as a result, when it hit in March and April, they simply didn't have the people available to do anything. They have since that time staffed up some, but it's still been a challenge to deal with that. Approximately 500 new people have been hired. Some of them began in May, and they're continuing to hire, and they have hired up, as I understand, up until 1st of October. But you're talking 500 people, and if you as an employer have actually spoken to some of the people on the phone that you're dealing with, you probably have come to the realization that you as an employer probably know more than the person you're talking to on the phone at the agency, because you have a lot of new people who really have not had proper training to deal with things. So while they have staffed up, just because they have more bodies at the agency doesn't mean that they have informed bodies at the agency. That takes time, and they really have not had time to train people. So a lot of the people that you're speaking with and dealing with at the agency, you're talking with people who have had 3 days of training and are trying to adjudicate things and follow the process. So as a result, as an employer, you're probably getting frustrated in dealing with some of these issues and challenges, but understand that's part of the reason why. So just because you're talking to somebody at the agency, and just because somebody at a claimant might be talking to someone at the agency, doesn't necessarily mean that you're speaking to somebody who is a well-informed person there. A lot of them have, like I said, had 3-4 days of training, and they're working from there. A good group of the individuals who they've hired are through a temporary staffing company in Chicago, so a lot of the people you're talking to work out of Chicago. And again, you're not only do people who are there hired have to learn the unemployment agency in terms of the rules and such, they also have to figure out their own computer systems and how that process works. So you're having a lot of challenges in that regard, and so it's just an immense and enormous problem right now. There are at least, that we are aware from reports from the agency, at least 75,000 unemployment claims that were filed in March and April that have not yet even been addressed by the agency. They are not following a process such as oldest to newest. In other words, what the agency actually is doing is that they are trying to process things as fast as they can. So if something gets handled or dealt with or filed, for instance, today, that can be handled quicker, they're going to deal with that rather than necessarily deal with something that's an older claim. So they're not following things in a prioritization of how older to newer. They're simply trying to follow a process of how fast can we get. If we can do 100 claims based off of here, they're going to do that as opposed to dealing with something where they can only process 10. So what's happening is a great deal of frustration amongst people. So like I said, you'll see situations of claims from March and April, May, that are still not able to get their benefits and are still having challenges. And as a result, you've got some people who filed claims in October who are getting paid, and people who filed in March and still aren't. And that's just a challenge that we're still going to have to deal with. There isn't much an employer at this stage of the game or a claimant can really do to get them forward, the claims from March and April. It really is going to depend on the actual claimants who filed the claims in March and April to simply hang on the phone for as long as it takes until they actually speak to somebody to try to get it moving forward, and that's really the best that can happen in those circumstances. The Michigan Works offices still remain closed, so the seeking work provisions are still on hold. Right now, individuals don't have to be seeking work in order to be eligible for unemployment benefits. And that actually presented a big challenge as it relates to the unemployment fraud claims that swept the state and actually the country. The unemployment claims that I talked about earlier that were 2.9 million, that didn't even include the 200,000 plus fraudulent claims that were filed as well, and all of the problems that incurred. The fact that there was no seeking work provisions helped exasperate that situation, because normally in a fraud case, individuals actually have to go down and file with Michigan Works and do things of that nature. Because of the fraud issue and the fact that the seeking work provisions were eliminated, that eliminated the need for individuals to have to do that, and that made the opportunity for fraud, identity theft fraud, even wider than it had been in the past. And I am going to go into some of the identity theft issues as well, because they were so immense and impacted a great deal of many people. What all of this means is that presently, I would fully expect that if you are an employer, that if individuals filed unemployment claims even in March and April and May of this particular year, it's going to take a very long time to get all of these issues resolved. And I would expect at least until mid to late 2021 and possibly even until January, February, March of 2022 before you're going to see a resolution to all of the claims that have been backdated and to have to handle. It's just going to take that long. So if you do have individuals who are asking you as to why it is that somebody is showing up as a charge to your account when we don't believe that it should be, there isn't going to be a lot right now as an employer you're going to be able to do to move it forward at the moment, because there simply aren't enough staff members at the agency to take a call from an employer to try to get something moving forward. Even if you do manage to get to speak to someone, they will only handle one unemployment claim at a time. So if you as an employer have multiple claims that you want to talk about, they'll only talk to you one claim at a time, and then you have to get back in line, kind of a thing. So it's just going to take a long time in order to be able to see some resolution to some of the determinations that have been issued and maybe problems that you're trying to resolve for your claimants or for you as an employer. The protest, if you had individuals who filed an unemployment claim who were discharged or who may have quit for non-COVID related issues, those particular decisions are going to take an even longer time, because the agency recognizes that that is going to require a lot more time to investigate for them. What is happening is that they're putting them into the let's address those later type bin. And so those type of issues are taking even longer than just the temporary shutdown or furlough type situations that were going on. Bottom line is that as an employer, we're all just simply going to have to be a little patient as we go through this process. It's going to take a long time, and you have to kind of recognize that, even though you might have people within your organization who might be pushing you to do certain things and then to try to get things resolved. The reality is there still isn't enough people at the unemployment agency to be able to address all of the problems right now, and it's just going to take time. So patience is really going to be the key issue here. Now, there have been some specific changes related to COVID that I do want to kind of get into. As a result of some of the efforts, and this was actually quite a big and important deal. Right now, the state of Michigan For unemployment, state regular unemployment benefits, and the claimant is eligible for regular benefits for 26 weeks up until December of 2021. Now, earlier in March and April, there was an executive order issued by the governor extending it from 20 to 26 weeks, and there were reasons why, because the federal government required the states to have 26 weeks of unemployment benefits in order for claimants from their states to be eligible for the federal extended benefits and additional payments. So that was the need for it. But when the court order was issued denying the executive orders, the government authority for the executive orders in this case, that put a huge, that was a huge potential problem. If the state of Michigan were not in compliance with that, then the federal benefits and everything would have been in jeopardy. So the fact that business groups, including the Chamber of Commerce and others, were able to work with the legislature and be able to get the 26 weeks until December 2021 is a huge deal for a lot of different reasons. But it is right now, claimants are eligible for 26 weeks of regular state unemployment benefits until December 2021. Now, there's also a federal extended unemployment benefit program, and a lot of U.S. employers might be beginning to see these coming in, and I'll show you some of that in a few slides down the road here. That is going to be eligible for 13 weeks of unemployment benefits after the 26 weeks have expired. So you're probably beginning to see a lot of federal extended unemployment benefit claims coming through to you as an employer. And those 13 weeks are right now going to be paid for by the federal government, or should be paid for by the federal government. Normally, it would be a 50-50 split between the state and the federal government, but because of some of the law changes that the federal government passed, the federal extended benefit program for the 13 weeks is going to be funded by the federal government for all taxable employers. Technically, it does not cover the reimbursing employers, but ultimately it will. What you'll find if you're a reimbursing employer is that you may see some charges and credits going back and forth on the extended benefits, but ultimately these extended benefits should be chargeable only to the federal government and not to you as an employer. Following those 13 weeks, that means, excuse me, individuals right now would be eligible for 39 weeks of benefits. Following those 39 weeks, there is right now, under the law, if the state unemployment rate of the state of Michigan exceeds 8%, then by state law, state extended benefits kick in which case an additional 20 weeks of benefits will kick in for individuals after that. So it is conceivable that individuals would be eligible potentially for as much as 59 weeks of unemployment benefits. Now, the 20 weeks of state extended benefits, that is something that will be split between the state and the employers. So that'll be a 50-50 split. Half of the state extended benefits will be paid for by the state and half by the employers when that gets to that stage of the game. So it is entirely possible that somebody who may have been laid off in March or April will ultimately end up getting 59 weeks of benefits up until approximately May of 2021. And that's if the federal government doesn't step in and add some additional benefits after that. I don't know if anyone remembers that back in 2008, at one point in time, as a result of state and federal extended benefit programs, there's actually an opportunity for individuals to collect 9 to 6 weeks of unemployment benefits back then. Right now, we're up to potentially 59 weeks, but it is possible that they could extend it beyond that. But for right now, 26 weeks of regular benefits, 13 weeks of federal extended, and then 20 weeks of potential state extended benefits after that. Right now, the state is still continuing to waive the requirement of claimants to seek work to qualify for unemployment benefits. However, while they're waiving that requirement, because of the way that the systems are built, the computer systems, it is not unusual for questions to come up and pop up. And if claimants answer things in certain ways, it could cause them to get a decision from the agency that says, oh, they're not seeking work, and therefore they're not going to be eligible for benefits. If a claimant answers questions in a certain way, that may happen. So if you have employees who are saying, hey, I'm not getting my benefits because it says that I'm not seeking work and I'm not supposed to, it's most likely because they answered a question that was posed to them by the state of Michigan and not in a correct way. And that caused the computer system to deny them benefits. But right now, claimants are not required to seek work at the moment. There has been an expansion of the work-share program as well. When I said an expansion, the state of Michigan basically made it so that more employers could potentially utilize the work-share program. And I'll go into some of what those changes are because I do have a work-share part here as well. So there has been an expansion of that work-share program. And work-share programs usually are designed for employers who have set hours for employees and who don't necessarily have hours that are fluctuating a great deal. So I'll go more into the work-share program in that regard, but right now there is still an opportunity for people to utilize the work-share program under new rules established by the state of Michigan that will still help them. And also, as it relates to the charges to you as an employer, it still remains that any unemployment benefits that were related to the COVID-related issues. So if you had to close down back in March, April, and May because of executive orders, or if individuals were laid off specifically because of COVID-related, they had to quarantine, or they were sick from COVID or something of that nature, any COVID-related unemployment benefit charges are still, at the moment, still to be assessed to the non-chargeable benefit component, meaning it should not be charged to your account. That is, however, a challenge in trying to determine what is COVID-related and what isn't, if you will, because a lot of employers are not able to operate 100% because of simply a lot of people are not willing to go out and do certain things. So now is that layoff that they might have to incur COVID-related or not, that becomes a question mark at this stage of the game. But theoretically, any specifically COVID-related unemployment benefit charges are supposed to be assessed to the non-chargeable benefit component, not to you as an employer. That, again, may change as we go into 2021, but for the moment, that's the way it's supposed to be. It doesn't mean that there will be no unemployment benefits charged to your account. It just means that if they're related to COVID, they won't be. And that becomes a challenge, especially as it relates to underemployment issues that I'll get to as well. A lot of employers are seeing underemployment benefits charged to their account, and they don't understand why. And I'll explain that when we get to that part of the presentation. But for COVID-related, it should not be getting charged to your account. I do want to, the first part of this, I do want to go into the tax process and also the reimbursing process, because this is going to be a challenge for employers over the next year. Typically, you will get your unemployment tax rate, and this is a copy of what you would normally see if you're a taxable employer. You would typically get this in December at the end of the year. And most employers are used to seeing a tax rate. In this case, it's a tax rate of 1.3%. And most employers, if they're in the finance area, will put down 1.3% as their tax rate, and they kind of budget for that for the upcoming year. And that seems like a very simple way to do things, and that should be set. However, this year is going to change this immensely because of the fact that there are so many claims from March, April, May, June, and July that are going to get charged and credited to your account that are going to change your tax rate after it is established initially in December of 2019. As an example, well, this is a different example. One of the changes is that they had eliminated some other penalties and stuff, but I want to kind of get away from that. But this is an example of what I wanted to go into, is that you'll see in this case it was a mail date of April 4th of 2016, and they changed the employer's tax rate from 2013 retroactively. And I'm going to go into a little more detailed explanation of that, but this is something that you can expect from a tax process to occur in the upcoming year. Your unemployment tax rate is likely going to continue to go up and down throughout the course of the year. So that if you're budgeting for a percentage of, say, 2%, it's very well that in January you could be seeing a 2% tax rate. In March you see a 2.2%. It could go back down to, in July, to 1.8%, depending on charges and credits that are issued as a result of the COVID issue in the state, then charges and credits retroactively. If it impacts your tax rate, it means that your tax rate will then get changed retroactively. So this is something that's really going to be important for employers to be aware of and to try to plan for, because if not, it could cause some shortfalls in your ability to pay certain taxes and such. Changes in the tax system. The obligation assessment was eliminated last year, and it should remain eliminated this year as well. Something else that's going to be most likely going to change, and this is something to tell your finance people if you're a taxable employer. Most employers were paying taxes on the first $9,000 that an employee earned with you. Coming up in 2021, that is likely going to be $9,500 for almost all the employers. The taxable wage base is determined based off of how much the state of Michigan has in their account, in their reserve account, and if it exceeds $2.5 billion, it reduces the taxable wage base to $9,000. But if it's less than $2.5 billion, it's going to be $9,500. I would fully expect that the state has not made a determination or issued this yet, but I would expect that this year that taxable wage base is likely going to be $9,500, meaning if you're an employer, you're going to be paying a greater tax this year because of the fact that you're paying more in their taxable wage base. And as I had explained, was kind of touching on about the retroactive tax rates, that's going to be the key issue for taxes going forward. And again, if you can, let your finance people know that just because they're going to get a tax rate in December of this year, that isn't a tax rate that they should simply put in and just automatically believe that that's going to be the same tax rate for the upcoming year. If you get credits or charges in January or February of 2021 related to anything prior to July 1st, and I would fully expect a lot of those things to occur, that's potentially going to impact your tax rate. And that means that rate's going to go up or down. And the real issue as it relates to that isn't just the fact that that now means that your tax rate is going up and down. It means that you as an employer are going to be compelled to have to pay those taxes within 30 days of that notification. The other huge thing is that the state of Michigan, their computer system will automatically assess interest off of those taxes. So in other words, if you had a tax rate issued to you in December of this upcoming year saying you had a tax rate of 2%, and because charges were suddenly issued in January, increasing your tax rate retroactively to say 2.1%, the state of Michigan is then going to issue a tax assessment saying, hey, you not only owe this additional 0.1% of taxes, but because you didn't pay those taxes on time, there is a interest that they're charging on that as well. And that I know as an employer that sounds pretty appalling. How can you possibly charge me an interest when I paid my tax on time and at the rate that they assessed at that time? It's a computer system issue that they have. It's what it does automatically. So expect that if you get a retroactive tax rate and it goes up, expect not only for you to get a bill for the tax, but you to also get an assessment saying you owe interest off of that tax as well. You need to know that as an employer, you can seek removal of that interest. However, in order to get removal of that interest, you have to pay the new tax, within 30 days. If you pay the new tax that they have now assessed to you, because your rate went from 2% to 2.1%, suddenly, you need to pay that within 30 days, and then you must request that your interest be removed. If you don't make that request, the state won't do that. They're not going to do it automatically. So you have to make an actual request to have any interest removed within 30 days, and it has to be paid within 30 days. And again, this can go on throughout the course of the year, and I would fully expect this to happen, where you're going to see tax rates going up and down within 1/10 or 2/10% throughout 2021. Both up and down, you might see lower, you might see higher. What I would recommend to employers, if they suddenly see their tax rate go from, say, 2% to 1.9%, you're probably going to see a credit in your account saying, hey, we show that you've overpaid your tax by $5,000. While you would have the opportunity as an employer to take the credit for the next quarter when you pay your tax, I really wouldn't recommend that at this time, because if the state should redetermine your tax rate again for the following year, they will automatically assess again the tax and the interest charges. But if the amount is already in your account, they're able to take that particular amount that's in your account automatically, and they won't assess the interest. So you won't have to kind of go through that hassle of asking for the interest and paying the tax in 30 days kind of a thing. So if you should get a balance in your account next year as a result of a retroactive tax rate reducing your rate by 0.1%, you may want to consider just kind of holding that for the course of the next year until that kind of plays itself out. Understand that the state of Michigan can also redetermine a tax rate up to 5 years old. Now, if that should occur, if the state of Michigan issued a tax rate for you in, say, 2018, and they suddenly redetermine it here in 2020, even though they're doing that for, 5 years later, even though they're doing it under state law, if they have issued a determination in 2018 and they change it in 2020, if that determination they issued is more than 1 year old, they do not have the legal right to issue a retroactive tax rate to you, increasing your tax rate. You have the right to protest it and take it to an unemployment hearing, because that's what it's going to take. You can request the agency to redetermine the rate and explain to them, hey, it's over a year old, and the law says you can't do that. The state of Michigan is not going to listen to that. They're going to compel you to take it to an unemployment hearing. But if you take it to an unemployment hearing, you will win. We've done this numerous times for employers throughout the state of Michigan. You go to an unemployment hearing, the judge recognizes that the determination is more than a year old, and they will not allow a retroactive tax rate increasing your rate, but it's going to take those particular steps. So if you should get a tax rate increase more than a year old, you can protest it and get it removed. But if it's less than a year old, the state of Michigan can and does and will continue to increase those tax rates up and down. So something to be really aware of, and let your finance people know that's a distinct possibility coming up over the next year as taxes floating up and down. Real briefly, there's 3 different components, and I wanted to kind of put this out here because of more as it relates to terminology, because claimants will file a claim, and they'll come to employers and ask them, what's our EIN number, because that's what the state is asking them for. EIN stands for Employer Identification Number, and the Employer Identification Number is what your state unemployment tax account number is, the SUTA number. So the SUTA number and the EIN number are one and the same. So if you have a claimant asking you, what's our EIN number, and there's a differentiation between an EIN number and a FEIN number. The FEIN is your federal employer identification number. That's a different number. But if your employees are asking you what their EIN number is, that means what your state unemployment tax account number is. That's what they're asking for. So keep that in mind, because that's a terminology that is confusing a lot of employers when their employees file for benefits asking for that number and they're not quite sure what they're looking for. That's what it is. There are 3 components to a tax rate: the NBC, the CBC, and the ABC. Normally, I don't touch on the first part, the NBC, the non-chargeable benefit component, because your account as an employer doesn't typically get charged for anything as it relates to that. Most of them, it's going to be about 1% per year. When I say your account doesn't receive any benefit from it, so you pay that 1%, but it doesn't go into your reserve account. What that money does go for and has throughout the years, it goes into a reserve account, and it pays for unemployment benefits where maybe an individual was originally awarded benefits, but then there was a decision later on saying that they should not have been entitled to those benefits, and then the claimant will later on say, hey, I don't have the money to pay it back. So typically, things that are in the non-chargeable benefit component kind of go paying for those type of issues, and the state of Michigan has, over the number of years, had a lot of money go into that particular component. Well, typically, the benefit of this component this year is that all the COVID-related expenses and charges are being paid out of this component. This is the balance that the state of Michigan had that was allowing them to be able to pay for the COVID-related issues. So the NBC amount component has actually played a pretty big role this year in keeping employers' tax rates down and reimbursing employers from having to pay benefits that they normally wouldn't have to do so. In the tax rate redeterminations, again, if your rate goes up, interest on those taxes is assessed automatically. You have 30 days to protest a tax rate redetermination if you believe it is wrong. Again, if it's over a year old, do that, but you have to do it within 30 days. If you don't do it within 30 days, it's going to become set in stone at that stage, and then you're going to have to pay retroactively. But if it is less than a year old, you have 30 days to pay the tax and to put in a request to have the retroactive interest payments removed. That is something you have to do. It won't be done automatically. It's really important for you to do that to avoid those expenses. The MyWAN tax system, really important for employers to kind of go in and check that, because the state is doing all sorts of things internally that they are not necessarily sending out documentation showing what they're doing. They're changing the numbers internally. So go back periodically to check and verify that the financial numbers that they have are correct. What I mean in that regard is that the state, and this is especially true if you're reimbursing employers, because you're going to find that your numbers are going to be completely different from what your quarterly charge statements are showing. Just because the unemployment agency has financial numbers up there doesn't necessarily mean they're correct at this point in time. They're doing things internally to change the numbers, and as a result, they may not be matching what you're showing yourself. So you want to go in, take snapshots on occasion to show that this is what they, as the agency, have had in their records. But just because the state of Michigan has tax numbers in their system doesn't make them right. That is going to be especially true since March. The unemployment agency's financial number systems, they're making changes internally without notifying employers, and it's impacting the employer's ability to validate and verify their taxes in that circumstance. So you want to go periodically check the tax numbers that they're showing, that they're showing that you have an outstanding balance, things of that nature, just to be sure that that's not going to impact you. This is, I know, very difficult for you to see, but this is what I'm talking about as far as taking a snapshot of on the MyWAM system for your tax. It'll show whether or not they have any retroactive interest or penalties or that sort of thing showing up suddenly. That may occur, and that's what you want to take snapshots of, especially if it'll show that there's nothing there. If there's nothing there, you want to take a snapshot, because a week later they might suddenly pop up and show, hey, there's a $1,000 that you owe from 3 years ago. Well, that makes no sense. And that's because internally the state of Michigan is doing things from their system and showing it. So that's why periodically you want to go in and take a snapshot of this kind of a screen and keep it to your system so you have evidence and proof that you were not 3 years ago late on something, that there's something kind of putting into the system. As I said earlier, the taxable wage base is likely. It is not official yet, so I don't necessarily mean this is an automatic. The state hasn't made an announcement yet, but I would be surprised if the taxable wage base doesn't go to $9,500 if you're a taxable employer. So you want to plan for that. If you're budgeting for next year, plan for it to be $9,500. If for some reason magically it doesn't go down, then you're going to have extra money in the budget that you didn't expect. So that's a good thing if you're an employer. But most employers should probably expect it to be a $9,500 wage base. For reimbursing employers, and this is going to become, I don't know how many employers out there are reimbursing as opposed to taxable, but this is going to be an immense challenge for reimbursing employers. The state of Michigan, if any employer received their second quarterly charge statements, will note that the state of Michigan, when they sent out those quarterly charge statements, informed employers that, yeah, here's what your quarterly charges are, but, oh, we understand and recognize that they are wrong. Nonetheless, the state of Michigan still issued invoices for the amount that the quarterly charge statements indicated they owed, even though the state of Michigan recognized and informed employers that it was wrong. So you're, as a reimbursing employer, you're going to be getting, and there are two types of reimbursing employers. There are governmental reimbursing employers. Governmental only have to pay once a year, and it'll be in October. In fact, they probably just received their invoices in October of this year for the calendar year of 2019. So governmental employers, this won't impact you as much, though it will come next year, but it won't impact you as much. Because if you're a governmental employer, your tax bill, or I'm sorry, your charge bill won't, your invoice bill won't come for 2020 until October 2021. But if you are a nonprofit, you might be getting reimbursing invoices quarterly, and if you are, most of those reimbursing invoices are going to be wrong. The state is most likely going to be asking you to pay for charges and benefits that they are ultimately going to end up crediting. But if you don't pay the reimbursing invoice on time, the state of Michigan will then assess you penalty and interest because of the non-payment. So as an employer, if you're a reimbursing employer, you are likely going to have to face a choice of, do I pay an invoice, that extra money for an invoice that I know is incorrect, and risk the fact that now that money is in the pay more than I should, or risk the fact that the state won't ultimately credit me for some of the charges they're assessing, and then I'm going to have to pay penalty and interest off the charge that I didn't pay. So if you're a nonprofit, I would not, it's going to be a challenge as to what you are going to want to have to do. But if you get those reimbursing invoices, expect them, if you're a nonprofit paying quarterly, expect them to be incorrect. The state of Michigan is just having a huge amount of problems in trying to properly issue the charges and credits during a period of time. So if you're a reimbursing employer, you're going to have decisions to make as to whether or not you should pay that bill in full, pay it partially, and hope that all the credits get issued. But if you pay it only partially or not at all, you are potentially risking having to pay a penalty and interest for the non-payment. So be aware of that. That's something that's potential for you if you're a nonprofit paying quarterly. I included this particular one because it shows that the employer owes 1 cent. The state of Michigan pays an enormous amount of money to send out invoices for less than 50 cents, costing them more money than it would be, but that's what they do. So you might get invoices for just pennies, and that does happen. This is what I kind of just went over and explained as far as the reimbursing employers. As I said, the quarterly charge statements, expect them to be incorrect to what you're actually going to end up owing. You don't have a right to protest the quarterly charges themselves, but you do the weekly charges. But frankly, and we do this, we do protest the weekly charges because we want to make sure that we have evidence that charges are being protested, but the agency really isn't looking at the moment to any of those protests, and I'll get to that when we get to the charging component of this particular webinar. But that is something that you probably are going to have to do to protect yourself, but don't expect the fact that you're protesting the weekly charges to be a benefit, at least not at the moment. All right, so I want to kind of go into the claims process itself and all of the additional documents and all of the additional determinations that you as an employer are almost certainly getting right now. The state of Michigan, historically, you probably would receive a monetary determination and maybe a determination explaining a decision allowing or granting benefits. And this year, though, you're probably getting dozens of additional determinations regarding certification issues, filing issues, registration issues, able and available issues. You're probably getting just an enormous amount of additional unemployment determinations than you had in the past. So I kind of want to go into some of this in terms of what to see and what to get. You may see this coming up on a lot of your determinations about a statement at the end of it saying, hey, you weren't timely in responding to questions that we had asked, and therefore you may come in January, you might get a determination saying, hey, you were not timely in responding to these claims, and therefore we're not going to consider you to be a timely employer. Don't worry about it. There's absolutely no genuine real penalty to when you receive this. We have had occasions where employers receive this and they had 40 and 50 individuals on there, and employers have been explained to us that they went and they validated the fact that they were on time to all of them, and it took them weeks and weeks to do that, and the agency then issued a determination showing that they were on time and they're not subject to these provisions. Don't do that when you get it, and almost all employers are going to end up getting it this year, because there are a lot of fact-finding forms going out that employers don't even have to respond to. So if you get it, do not be concerned about receipt of it. There are no penalties issued to this that don't already exist. It sounds foreboding. It sounds like, oh, I didn't do my job. That's not what this is at all. This is a system issue that the agency has. They might be sending out fact-finding forms about issues related to able and available issues for claimants that you yourself have no knowledge about and can't respond to. And so you don't, and as a result, they'll say, oh, you didn't respond to it, and therefore you're now an employer who's not in compliance. Don't worry about that at all. When you get this in January, and most employers are probably going to get this in January, do not take the time to show or to prove to the unemployment agency that you were timely, because there is really no penalty to this. What all this is going to say is that in the future, if you are late on any responses to a claim that the agency sent to you, they are not going to retroactively remove any charges to your account. Well, guess what? They do that already. If you're not timely now to any claim, and benefits were paid out, you don't get those benefits removed from your account because you weren't timely. And that's all that this is saying, is that they're going to do that. So don't be concerned when you get this in January. Don't take the time to respond to the agency. Like, so we had employers at other seminars say, hey, they took weeks of their time to respond to it and get all the information. It didn't benefit them at all. So don't worry about it when you get this in January. Bottom line, unemployment insurance is designed to provide benefits to individuals who are out of work through no fault of their own. Whenever you're responding to an unemployment claim, keep that in mind. That's something that you as an employer will want to try to use as a judgment. Did they lose their job through no fault of their own? If they lost their job through no fault of their own, they're going to be entitled to receive unemployment benefits. If they quit their job, if they were discharged for policy violations, something of that nature, then that is something that they have control over. But generally speaking, unemployment is designed to give benefits to individuals who lost their job through no fault of their own. Some basic concepts of unemployment. Claimants have to first off qualify monetarily. And every state has different monetary qualifications. The separation issue is reviewed by each state to determine if it was a disqualifying reason. So the first thing is they have to qualify monetarily. The second is, did they qualify based off of their reason for separation? If they meet those two particular hurdles, then they have to meet a third hurdle, which they also still have to be able and available for full-time work. But they have to be able and available for full-time work after the claim is filed. That is a key distinction. They may not have been able and available for full-time work while working for you, but after they file the claim, if they make that assertion, they will be entitled to receive unemployment benefits. So if you're a claimant, those are the 3 hurdles that you have to establish: that you monetarily qualify, that your separation was through no fault of your own, and that you're able and available for full-time work after you have filed the claim. You don't have to be unemployed to file or receive unemployment benefits. There is this thing that's called underemployment, and individuals may be entitled to receive unemployment benefits while simultaneously working for you. In fact, that's probably one of the more aggravating things that employers are having to deal with, is the fact that it is not, especially right now, it is not uncommon for individuals to have multiple jobs. They may have lost their one job through COVID. Maybe their place of business closed down, and so therefore they filed an unemployment claim. They're still working for you, still working the same number of hours. Nothing has changed, but because you are in the base period, you're going to get dragged into that particular unemployment claim. And you, even though they have not separated from you, even though there is no reason, no change of employment whatsoever, you as the employer may end up having to pay unemployment benefits as a result of the fact that they separated from another employer. That's entirely not only possible, but it's happening quite a bit. And the increasingly more frustrating part of it is that because of the way that the executive orders and rules were issued, employers in that particular circumstance, their benefits are going to get charged to their account. They're not going to go to the non-chargeable benefit component because their unemployment benefits that are being paid out by you to these underemployed individuals were not COVID-related from your employment of separation. They were from the other employer, but not from yours. And so as a result, employers who may not have let anybody go, may have continued to pay them, may have had no separation or change whatsoever, may end up having to pay unemployment benefits during a period of time because an individual lost their job to another employer. That's simply the law, and there really isn't anything that can be done on that. Monetarily qualifying in the state of Michigan, right now you have to have earned at least $3,744 in your high base period quarter. And when I say quarter, that means they are distinct. January, February, March is the first quarter. April, May, and June is the second. July, August, and September is the third. And October, November, December is the fourth. An individual must earn at least $3,744 in the high base period in order to be eligible for unemployment benefits. They also have to earn at least $5,616 in total over the base period in order to be monetarily qualifying. Now, if their high amount in their base period, for instance, was $10,000, maybe they earned $10,000 in their high base period quarter, that means they have to have earned at least $15,000 in total over a year in order to monetarily qualify. So that's the minimum that they must make monetarily in order to qualify for regular state unemployment benefits. And again, those wages can be based off of multiple employers, not just necessarily one. So even though they may not have earned $3,744 with you, it might be for the entire employers. They might have 2 or 3 employers. Pandemic unemployment claims are not subject to meeting those particular requirements. In fact, that's specifically one of the elements of the pandemic unemployment claims are that they don't have to meet those, is that they can't meet those requirements. If they don't monetarily meet those requirements right now, they can still file a pandemic unemployment claim up until December of this year. They're not eligible for additional federal benefits or funds right now. That does not exist for any claimants at the moment, but there's still a minimum amount of pandemic unemployment benefits that they might be eligible for if they file. So right now, for regular unemployment benefits, state unemployment benefits, they have to earn at least $3,744. But if they didn't, they are, at least until December of this year, eligible for some pandemic unemployment assistance that is not chargeable to your account. So this is, the $3,744 is for state regular benefits, not for the pandemic. That they only had showed they had wages, period. If a claim was filed in April of 24th of 2020, the base period that they're going to use, when I say they, that means the unemployment agency, they're going to use this period. They're going to say, okay, you filed in April 2020. They're going to base their unemployment benefits based off of January 1st of 2019 to December 31st of 2019. That's the time period they're going to use to determine whether or not they're eligible to receive unemployment benefits chargeable to your account if they filed that claim on April 24th of 2020. And the reason I use April 24th is because the quarterly wage detail reports are due on January, April, July, and October 25th of every month. And anything up until April 24th, that first quarter is not necessarily has to be in the system, so the agency doesn't use that first quarter as a result. Now, if an individual filing for benefits in that time period doesn't monetarily qualify, under state law, the state can actually still go back further for another 3-month period and use the period of October 1st of 2018 to September 30th of 2019. If that allows them to qualify, they'll use that. So it's possible that an individual that you separated in October of 2018 doesn't file an unemployment claim until April of 2020, and they may still get you may still get dragged into that unemployment claim. So be aware of those particular time periods. Just because somebody separated you from you 15, 16 months earlier doesn't mean you may not get dragged into an unemployment claim later. There's also the issue of an incomplete or delayed quarter. Again, if they filed in April of 2020, that means that any wages they earn with you from January 1st of 2020 to March 31st of 2020, that's available for them to be used in a future unemployment claim. So maybe they collect their 52 or 53, 59 weeks. I'm sorry, my math is going off here. 59 weeks of unemployment benefits. They are potentially able to file another claim following receipt of those benefits using the wages that they may have received from you from January 1st of 2020 to March 31st of 2020 and another claim a year later. That is entirely possible. So you could end up having to pay unemployment benefits not just for 1 year, but for 2 years. That is entirely theoretically possible and does happen. So be aware of that. Individuals will have 52 weeks in order to collect their unemployment benefits. And after 52 weeks, they will be expected, even though they are eligible for 59 weeks of benefits, after 52 weeks, they're expected to file a new unemployment claim. If they can financially qualify, monetarily qualify for a new unemployment claim, the state of Michigan will use the new claim going forward. If they can't monetarily qualify, then they will continue to receive the extended benefits for another up to 59 weeks. So after 52 weeks, they have to file a new claim. If they monetarily qualify for a new claim, they could get another 20 weeks of unemployment benefits at that stage of the game. So it's entirely possible at that stage it's 72 weeks of unemployment benefits. But if they don't monetarily qualify, then it would be 59 weeks in total. I do have a question came up. It says, if an employee is receiving monies for being underemployed because they had more overtime last year than this year, will they still only have 26 weeks to claim? Some employees are receiving sums of $30 to $50. What happens if they get laid off after the 26 weeks? If they get laid off and after receiving the 26 weeks of unemployment benefits from regular state unemployment benefits, or if there's been a reduction of employment from that point, they still would have to, they would be eligible for extended unemployment benefits at their full amount. So they would, so if they're receiving partial unemployment benefits for 26 weeks, and I think this is what the question is asking, would they be eligible for more than that? If they received underemployment for 26 weeks, then they lost their job, they would then be eligible for the extended benefits at their full amount for the next 13 weeks for federal, and then potentially for 20 weeks after that. So I think that's what the question is asking. So the fact that they're collecting underemployment benefits will not mean that they won't be able to collect full unemployment benefits for their extended amount later on. But it will only be at the amount that they originally filed their unemployment claim for. So if they were eligible for $250 a week in state weekly benefits, when they go for their extended unemployment benefits, that's all that they'll be eligible for, even if they may have had overtime and that sort of thing. That's not going to impact it at that stage. I think that's, I hope that answered the question. Just so that individuals know how to compute how much they're going to receive in benefits, 4.1% of the high quarter earnings. So if somebody's high quarter earnings were $5,000 in a high quarter, if you want to know how much they're going to collect in unemployment benefits, multiply that by 4.1%, you should get, I believe, $205. That's how much an individual will receive in unemployment benefits, up to a maximum in the state of Michigan of $362 at the moment. There is presently no federal extra benefits right now. So right now, only for the state weekly benefit amounts. 26 weeks of state benefits until December 2020. If an individual collects 26 weeks of benefits before December 2020, they will be eligible to collect the 13 weeks of extended benefits beyond December. So provided they are part of the extended benefit program for the federal extended benefit program before December of 2020, they will collect the full 13 weeks afterwards. Now, if their 26 weeks of benefits goes until January of 2021, then they are not going to be eligible for the 13 weeks of federal extended benefits at that stage, because they didn't receive extended benefits before the program ended in December 2020. So long as you received, so long as you applied for the, I'm sorry, not applied for, you don't have to apply for the extended benefits. It simply is automatically given. Provided you are in the extended benefit program before December of 2020, December 29th, I believe it is, of 2020. If you are receiving extended benefits before then, you are entitled to receive the full allotment of 13 weeks. If your 26 weeks of benefits extend until January 5th of 2021, then you are not going to be eligible for anything of the federal 13 weeks of extended benefits, though you would be eligible for the 20 weeks of state extended benefits. So if you're an employee, a claimant, whether or not you're going to be entitled to the federal extended benefits depends on when your 26 weeks expire. If your 26 weeks, you claim 26 weeks before December 29th of 2020, then you're eligible for the 13 weeks going forward. But if not, then you're not going to be eligible for that, but you would be for the 20 weeks of state. I know it gets a little confusing to trying to explain to claimants how much they might be eligible for weeks, but it depends on when the programs expire. And claimants are eligible, for instance, maybe their weekly benefit amount showed that they were eligible for $300 a week in benefits. And it's possible they could get more if they showed that they have dependents. They can get $6 a week more in benefits for up to 5 dependents. No matter what happens, though, they're not going to be eligible for more than $362 a week. So that only comes into play if somebody is eligible for less than $362 a week, where they could potentially get $6 a week more for dependents, up to $30. And the last employer is liable for the first 2 weeks of unemployment benefits. And the last employer issue is kind of key. The last employer is the one who determines whether a claimant is going to be entitled to receive unemployment benefits at all. If you're a base period employer, the issue is not whether or not the claimant is going to, whether their separation from you is going to lead to their receiving benefits or not. If you're a base period employer, that will only determine whether or not your account is going to get charged for benefits or not. Only the last employer will determine whether or not somebody is going to be eligible for unemployment benefits or not, chargeable to either their account or not, or whether they get benefits at all. So it's possible that maybe somebody 6 months ago, you laid them off, And so therefore they would have been eligible for benefits from you, but maybe they got another job. And in that other job, they were then discharged 6 months later. And if that employer protested the claim and they were denied benefits, then they would not be entitled to benefits at all, and your account won't get charged either. However, if that particular employer also laid them off, then that employer is going to get charged for the first 2 weeks of benefits in total. And then after that, you will get brought in because they were laid off from you as an employer. You'll get brought into the claim from that point, and depending on how much the proportion of the benefit of the claim was. So if you paid 20% of the wages to determine their monetary amount, you'll get charged for 20% of the benefits going forward in that case. Unless the separation from you was for a disqualifying reason, that maybe they quit, in which case then you can contest the charges to your account and not have them charged. But that won't impact whether that person will be eligible for benefits or not, only whether or not your account is going to get charged. And this is just a copy for those who may not work with that, but this is just a copy of what a monetary determination, or in this case a redetermination, is. The state of Michigan is primarily now issuing only monetary redeterminations, which is getting to be a point of confusion, but because there are specific protest guidelines to monetary debts and redebts, but they're primarily only issuing monetary redeterminations to give them some flexibility internally in terms of how they handle claims. That's why they're doing it. This is a case where the claim was filed on August 13th. They actually filed the claim on August 11th, but it wasn't actually created or generated by the agency until August 13th. And it shows potentially two different employers, one where they had a leave of absence, one in which they were unreported as to the reason as to why they left that particular employer. One is liable for $4,347 in this claim. This is the claim that starts the process off. And if you as an employer wish to protest it, this is the starting point. You need to protest this particular claim. And let me kind of go into this a little bit more. This is just another claim in which an individual filed in May. And you'll note that in this case, it shows that they did not monetarily qualify, where you show that the total potential maximum benefits charged to your account. Where you see that there are no charges to that, that means your account won't get charged. Doesn't necessarily mean that they won't receive unemployment benefits, but it does mean that your account should not get charged. This is an example of what would have ultimately led to a pandemic unemployment claim. An individual didn't monetarily qualify, so you would have received this as an employer, but the individual then would have been eligible for a pandemic unemployment claim. A question came up saying, when responding to monetary redeterminations and requests for information through the MyWAM portal, it only gives you the option to protest, even if we are simply providing the financial and employment status information that is requested by the form. If there's nothing to protest, should we simply not respond? If there is nothing to protest, in other words, if it is a temporary shutdown or a layoff or something of that nature, then no, you don't have to protest. You don't have to respond. Now, we were actually informing employers, especially back in March, April, May, and June, that they probably still should have then, because it was good information for the agency to have from the employer to show that they were not protesting the claim. It might help move those claims forward. But at this stage of the game, it isn't something that's going to be as important to do so. So if you are not protesting the claim, no, you don't have to do so. There is there should be an option, or you simply say that you're not protesting, and you click on that, and that should be sufficient as well. But no, you don't have to respond if you're not actually protesting the claim. That will not impact you as an employer at all. So you don't have to do that if you don't want. We, as a third-party administrator, we do, because we do want that in the unemployment agency's record to show that the employer, that the information is matching up with what the claimant says, that it was a lack of work. We do that because if it's actually a lack of work, it may help the claim move forward a little bit faster. the agency will see that there's information from the employer saying that it was a lack of work and matches up with what the claimant says, and it may allow the claim to go proceed a little faster, but it's not something that you have to do if that's something that you choose not to do. This is a copy of what's called an extended benefit claim. This is what you're going to be receiving a lot of going forward, because a lot of those claims in March and April are reaching their 26 weeks now, and as a result, they are now issuing extended benefit claims. A couple things is that claimants do not have to file a new application for an extended benefit claim. In fact, the claimants really don't have to do anything at all. It should automatically come into their system, so that if a claimant asks you the question of if they have to do something to get extended benefits, and the answer is no, they shouldn't. All they have to do is continue to certify for unemployment benefits like they normally would. As an employer, there is no reason for you to contest an extended benefit claim unless the employee is actually fully employed or has become employed with you again. If you see this come up and someone is working for you, well, that is something to protest. But otherwise, there is no reason to protest the extended benefit claim. It's simply informing you that they have filed that claim as informational purposes. Now, you'll note on here the extended benefit claim shows that there's a maximum charge and a non-charge amount, and it shows 50% of it being the maximum charge to you as the employer and 50% being the non-charge. And this is part of the point of confusion that's going to kind of go forward. Because the federal government, in the CARES Act and the first Coronavirus Act that they passed, they made changes to the particular law that the first 13 weeks of extended benefits, the federal government is going to pick up. So even though it shows that there's a maximum charge on there, you as an employer should not be getting charged for the extended benefits for the first 13 weeks, even though it shows that that's the case. Now, that will be true for the state extended unemployment benefits of 20 weeks when that kicks in. In that case, then you as an employer may end up picking up the 20 weeks, half of it, of a maximum charge. The state has not yet adjusted their forms that are going out, so if you're receiving this as an employer, the first 13 weeks should not get charged to your account. After that, the next 20 weeks may very well end up getting charged to your account. So when you get this, just be aware of that. Another question, so you're saying if it's any sort of COVID-related absence, the employer will not be charged at all. If so, how do we know if it's a COVID-related claim or not? Often we only see it listed as a leave of absence or hours reduced or working part-time hours rather than seeing a COVID-related reason listed. You as an employer, if you get a claim, need to inform the state of Michigan when a claim is received in this case. For instance, maybe someone has to quarantine for 2 weeks, and therefore they file their unemployment. Well, or if they actually receive, or if they actually have some specific. Let me give a different, because this is one that's more common, is that individuals are having problems with childcare because some are going to school, some are not going to school. Hours are being changed, as whether it's in person or not, and so they're having issues related to that. You as the employer need to inform the unemployment agency that the reason why it is your understanding as to why a person is not able to continue to employment with you is related to that COVID related issues. You need to do that in your protest. Now, when the claimant files their unemployment claim, it is important to you as an employer to ask the claimant that when they file their claim, there are drop-down boxes when they click on it. When they click on it, it might be a lack of work or a separation reason. When they click on it, another drop-down box will show up, and then it will have a listing of items about COVID-related. It would be helpful and important for claimants to specifically identify, to do that, and then identify it being a COVID-related reason as well. Because if both the claimant and the employer state that, it will make it easier for the state not to issue charges to your account. Whether or not the actual issue is COVID related or not is going to be dependent upon what your employee informs you of. If your employee informs you that I need to take a couple of weeks off for whatever issue and it's not COVID related, well then it's not COVID related, and therefore you need to inform the agency of that fact. But if they say that it's COVID related, that maybe they have a family member who is ill and needs to be taken care of at home and that sort of thing, that's something that you need to, the information you need to get from your employee and inform the agency of that fact when you respond to them, because that might determine whether or not your account is going to get charged for benefits or not. Let me see here, another question. Determination declares charges to my account are non-chargeable, but charges are still hitting my account. Do I need to file a protest, or will this be sorted out? And this is, and that's a great question, because that is happening a lot. And again, these are being charged to your account in error. My answer to that would be yes. I would recommend that you still protest any charges. You don't have to do it every week, but the first week you show any charges coming to your account, we would recommend that you put a charge protest to the unemployment agency so you have it on record. The unemployment agency is charging and crediting, and it's going to be a very confusing time period for employers to be able to keep track and manage that. One of the other huge issues is that the unemployment agency, and I'm kind of jumping ahead of myself here, but I want to at least kind of get the question answered. The unemployment agency is internally issuing credits, but not showing the credits to be issued in a charge statement later on. So that you as an employer are then having to try to figure out, well, wait a minute, I should show that there are $20,000 in charges based off of the weekly charge statements, yet the agency's MyWAM system is only showing $10,000 in charges. That becomes a huge challenge for employers to then figure out, well, who did they credit and who did they not credit? Because the agency isn't doing that for employers. They're only showing internally they're issuing the credits, but not necessarily doing it in a written statement that you can then validate. So that becomes an issue that employers have to deal with. So if you should be getting that as a problem, yes, if you see a charge on your account that you don't believe you should be charged for, protest the charge statement. Do that. That is a really important thing to keep that in mind for that. 4, and I hope everyone is able to continue to hear me here. It looks like there might be some sort of issues about my speaking and coming over in a timely manner. Hopefully that's corrected. Extended benefits, again, you don't have to protest these. These are only explaining to you what is going to be happening for the claimant primarily. But for extended benefits, if you see any benefits getting charged to your account off of an extended benefit, absolutely protest those. They should not be for the next 13 weeks. After that, 50-50. The only reason you'd protest an extended benefit claim at this stage is if those particular individuals are employed fully with you and have returned to work, in which case inform the agency of that fact. This is a copy of the back of a monetary determination. And these are things that are going to be very important for you as an employer to keep. The reason is because you will see in the back, in this case, I have it kind of highlighted, it says charges to your account are going to be assessed in the non-chargeable benefit component through September 5th of 2020 because of executive order, These statements are constantly changing, and they're different. They have different dates, different times. Even though these statements are showing up on the monetary determinations, as some of you are recognizing and seeing, charges still suddenly appear in your account for these particular individuals and claimants. And that's why, if they should show up, you need to protest them, and why you need to keep these particular documents, because they are evidence that you should not be charged. If this is on a monetary determination or a separation determination, then you need to keep these particular documents. And at some point in time, if you don't see the credits coming to your account, pursue them, and you'll have evidence of that fact. So it's really important to actually keep all these particular documents as evidence for your future protests, to be able to say, hey, I received this document from the unemployment agency. It says these charges are to be charged to the NBC, therefore I should not get charged. It's going to be important to keep these documents. If you were not keeping the backs of these documents or keeping the files of them, I would really recommend you do so beginning now, or if you haven't been in the past, or keep them, because this is really key evidence to keep your accounts from not being charged. It doesn't mean that the agency isn't making errors in charging them, and it doesn't mean that you're not going to have to take steps to be able to have to get them removed, but it is proof and evidence that it shouldn't be, and that ultimately you should be able to get the charges removed. The biggest challenge is in determining, because the agency isn't informing employers all the time of who's getting credit or not, trying to keep track of that. It's going to take a Herculean effort for an employer's part to be able to validate some of those charges on your accounts. How about, it's at 10:20, and I give everybody maybe about a 10-minute time period to get a coffee, a water or something, maybe stretch, and that sort of thing. And we'll take about a 10-minute break and return at 10:30, and we'll pick it up from that point.
just wanted to give everybody a 2-minute warning.
Okay, everyone. It is 10:30, and hopefully everyone's back, and we can kind of go forward from here. There is an outstanding question I wanted to get to. And the question is, I am currently receiving a charge statement for employees where we're only charged for approximately $10 when they are receiving $362. Can you explain? There is at least one explanation that is logical, and one which could also be not particularly logical, but it could be happening. But the most likely explanation on it is that this particular individual may have qualified for unemployment benefits with multiple employers, and they may be receiving the full amount of $362 in benefits, but you as an employer may have only been one of multiple employers and therefore only getting charged a portion of it, which might only be $10 a week. That's what the scenario should be. There's also the possibility that the unemployment agency is simply making a gigantic error and messing up. That's also a distinct possibility. I've been doing this for 25 years, and in the last 6 months, I have seen so many different problems and issues that I have never seen before in the other 25 years. You have to understand that the unemployment agency systems, they're trying to change their computer systems on the fly, and a lot of times they'll make a change to make one change one way, one change another, and not realizing that change can impact other things, and they will have created another problem. I have seen that where these kind of things happen, where all of a sudden employers only getting charged part of it. The only reason why that should be happening is that if you are a employer that is one of multiple employers and you're only picking up a part of the benefits. But if it's for any other reason than that, then that's an agency error. And I have seen those kind of errors occur over the last 6 months because of some agency issues. But the only logical reason is that there's multiple employers, and that's why. For this screen, I just kind of wanted to show everyone that the back of the monetary determination. This is another example where on the back of the monetary determination, it's showing that this particular employer won't get charged through August of 1st of 2020. So in the one prior, it was for September, the August. It's important for you to keep these particular documents because they're constantly changing the dates in terms of when things are going to be chargeable and not chargeable. And it's important for you to keep them because the agency may make errors in their process and charge you when they shouldn't be. So keeping them is important. Reasons for separation. Lack of work. An individual is entitled to receive unemployment benefits for the most part for lack of work. For the most part, they should not be eligible for voluntary quits, though there are occasions when they could be, and we'll kind of go over them. Discharges, an area that they for the most part, again, should not be eligible for benefits. However, there are occasions for discharges where they might be. Leaves of absences, and in this COVID era, that is, there are occasions where they should be eligible and other times where they won't. Historically, they should not be eligible for any unemployment benefits for a leave of absence, but because of the Families First Families First Coronavirus Response Act and other legislation, there are occasions when somebody, if they are on a leave of absence for COVID issues, could be getting unemployment benefits as well as potential for payment for regular employers as well. So, for generally speaking, they should not be eligible for leave of absence, but they might be in this COVID era because of COVID issues. For disciplinary suspensions, they should not be eligible for unemployment benefits either. And for underemployment, that is you may have reduced their hours or their wages, and in which case they would be eligible for underemployment. So that is another reason that they could get benefits for. Upon receiving a monetary determination, you have a 10 to 30-day appeal period, 10 days to be considered completely timely, meaning there would be no charges to your account if the individual is found to be disqualified. You still have a 30-day window, though, to appeal any separation issues, and which would disqualify an individual from the time period that you protested up until 30 days. So if they received 2 weeks of benefits because you were late for by a 2-week period, those would remain charged to your account, but they would be disqualified going further if the reason why you supplied them was within 30 days and it was a disqualifying reason. All quits actually have a 30-day appeal period. So if somebody quit and it was on day 28 and you first responded, that is still considered to be timely on quit issues. For monetary determinations, as I think I indicated earlier, there is a difference between a last and a separating employer and a base period employer. The last separating employer determines whether or not an individual may receive benefits or not. A base period employer, the only issue is whether or not your account is going to get charged or not, and those are two different things as an employer to be concerned about. And the monetary determination, again, review the employer charging messages on the back, which is what I just kind of covered. It's especially true for COVID issues, because if there is a statement that says your account shall not be charged or will be charged to the non-chargeable benefit component, you need to verify, match them up, because you may see charges appearing on your account that you have to go back and forth with the agency on. It's going to take time, but it is something that you're going to have to keep verifying and validating to make sure if there's a statement saying your account shouldn't be charged for benefits, protest the charges, and ultimately they will get credited, but it's going to take time. And I can't emphasize that enough, because the agency is still overwhelmed. It's not something that you're going to protest and a week later you'll get credits to your account. That's not going to happen. It's going to take months before you might see that happen. There might be occasions where you do see it within a week. Again, they're not taking things on a priority basis of saying, hey, this was protested 6 months ago, let's address this first. They're not doing that. They're kind of doing it on a case-by-case basis. How can we move as much as we can first out a basis is kind of how they're addressing things. Did want to get into, because it became such a huge issue over the summer, and well, I'm sure it's going to pop up again, fraud and identity theft claims. If you get a non-employment claim, it is important for you to verify with the employee who's presently working for you if they actually filed the claim or not. It may not, it may to you seem like illogical that they did. Why would they have? But we have found in numerous circumstances that there were some individuals who our clients thought had not filed the claim because they were still getting paid. Why would they do that? But they actually did file the claim. So verify with them just to be sure. And that was especially true when the federal government was paying the extra $600 a week in unemployment benefits. There was some confusion by people about that, and so some people were filing claims when they logically would not normally have done so. So verify with them, even though it might seem unlikely. If anything comes up on an unemployment claim showing temporary shutdown as a separation issue, that is something as an employer it might be to key in on as far as it being a fraudulent claim. When you do verify that a fraudulent claim has been filed, you can notify, and you should notify both the agency and through the MyWham system of it. There is if you go to your MyWham, there's a specific portal, a link that allows you to click on it and says for fraudulent claims, click on it and report it as an employer. Also have the claimant do so as well. Don't just do it yourself as an employer. Have the claimant, both you as the employer and the claimant should do that. You really want to make sure both sides do so. It's on a claimant can do so by just going to the unemployment agency website. They have a link that says if you have they may not have a claim established themselves, a MyWham account, but they can click on the link on the agency site that says report identity theft, and that'll lead them to the ability to report for themselves. That's important for them to do that. I have on here, report the fraud either online or call the 1-855 number. Don't call the 855 number. That is simply not working. It was so overwhelmed, it was wiped out. So just do it online. There really isn't an opportunity for them to do that. Fraud claims typically we're taking 15 to 18 months to resolve and investigate. That isn't true at this stage. For most of them, they actually are resolving many of them. However, there was a circumstance, and actually there are two instances where there were two individuals employed by the state of Michigan Unemployment Agency who were part of various operations to commit identity theft. This is an issue that's impacting some of the people who were victims of identity theft and others who were not. The ones where the individuals were victimized by a couple of people within the agency themselves, they're the ones who are going to have the biggest problems going forward, because what happened in those cases is that the two people working inside of the agency who were doing this, and there were a lot of other people who are not outside who were also doing it, but the two that were inside, they were automatically approving the benefits immediately. And so what was happening is that the agency was then issuing payment to the accounts that were not associated with the fraudulent victims, and the agency system is having a difficult time catching up with that. Their system shows payment was made to an individual, and they're having a difficult time getting that credited out, so that the victims of identity theft who may have been victimized by the internal criminals are having a much more difficult time getting their identity theft claims resolved than individuals who are victimized by people who are working from outside the agency. So there are two different things going on there in that regard. Question being, when responding to a request for more information, I've never been able to find on the MyWham site where to fill out the questionnaire online. Can you help me with this? A couple things. It depends on the fact-finding form that they are sending out, or the request. I call it a fact-finding form. They are referring to it as the request for information. There is a link within MyWham system if you're trying to do it online, where they have a link that is specifically identified as fact-finding forms, and that would be I don't have a screenshot of it. I guess next time I'll try to make some screenshots of it when I do these things, so it'll kind of show you where the link might be. But typically it'll be, there's a determinations and decisions link. Click on that, and when you do that, there should be another link that shows for fact-finding forms where you can click on that, and then the fact-finding forms should show up on the system. Not all fact-finding forms are on the MyWham system, though. I know that sounds odd, but again, their system is sending things out both by paper and by internally in the computer. So there is a link that specifically is on the MyWham system that is specifically tied to fact-finding forms, and you can click on that, and that should get you to most of them, but there are some fact-finding forms that aren't showing up on there. Also know that a lot of times the request for information form that they send out, and again, I call it fact finding, and actually on the MyWAM site they call it fact finding. The questions that they might be asking of you are not necessarily related to the actual claim, or related to the separation, I should say. There is once you click on the fact finding form, and I think I do have a screenshot of that coming up in a little bit, where you can change what the questions are. It'll allow you and allow the agency to have different questions online if you're going to respond to it that way. But keep in mind that not all fact-finding forms are on the agency website. So you might, the agency, if you're getting things in paper, you might actually be getting more things in paper from fact-finding forms or requests for information than you are. We'll find them online. So that is happening right now as well. Another question about, I filed an identity theft claim for an employee months ago. The employee filed too. Nothing's been paid out on that claim, but I never received any type of acknowledgement from unemployment. Did they send redeterminations? Yes, they do, but that is not an unusual, what you just described is not an unusual circumstance. The agency is wading through all of these fraudulent claims. Like I said, there are over 200,000 in Michigan alone, and it's taking them time to do so. I'll show you a couple of the determinations here shortly about what they are sending out. Part of that might depend on the agency may have attempted to contact the victim, and they may have left messages or something of that nature, and they may or may not have connected with that person. If they left messages and they did not actually ever connect with them later on, that might be a circumstance that's getting delayed longer because of that fact. But if they did verbally connect with them and speak with them, generally speaking, they are able to get some determinations out that'll show that it's being cleared up. I will show you a couple of those determinations shortly about what they look like. Ultimately, you should get something, both you and the claimant, the victim should be getting something in the mail from the agency indicating that the claim was either canceled or that it's being considered null and void, or that they did not report the information as requested, and therefore they're canceling the claim. So I'll show you a couple of those in a moment. But ultimately you should, but the fact that you haven't is not unusual. 200,000 plus fraudulent claims, and it's taking them a long time to wade through them all. As I said earlier, part of the problem is the state was approving, especially internally, the claims before the claims were even getting generated. We had noticed that that was where the issue was with some payments were being issued before we even were aware that the claim had been generated, because they hadn't generated the claim yet, the state of Michigan. That was the cases where there were people internally doing it. Those are the ones that are going to be a particularly more difficult issue to get resolved, because payments were issued and the computer system of the state just recognizes that payments were issued and they want their money back. And so that's the cases where you're going to have individuals saying, I'm getting notices from the state, demanding money, what's going on? I notified the state, you notified the state, and they're still demanding this. And so there are some steps to take in that regard. For them, if they should ever get, and I'll show you, it's called a weeks of overpayment notice, and when we get to that, I'll explain that in a little bit more detail as well. But if you have individuals who get the weeks of overpayment notice or demand for restitution or of that nature, do not, and they are victims of a fraud, do not pay them. Make sure that they know that they should not pay that amount if they were victims of fraud, because trying to get the money back is going to be next to impossible for them. So, but when I get to that form, I'll explain that a little more in depth. Like I said, notify the agency that fraud was committed by the MyWAM account. The agency did set up a whole process and system where they were contacting all individuals who they thought were victims of fraud. They were leaving them voice messages, or sending things via the mail. They were trying to do things to connect with people. The ones where they're actually able to connect with, those are getting resolved much faster than those where they did not actually speak to someone. So let your folks know that if they have not received anything, that if that's the case, any notification from the agency that they may want to call the agency and to see if they can try to get something moving forward before something does happen later on that's a bigger problem. And also know that none of the fraudulent identity theft claims are related in any way to a breach in any employer systems. No employer systems were violated or broken into. They were some financial systems that we believe were primarily tied to FAFSA, loans for student loan programs. That seems to be the driving force, that if there was FAFSA applications made, that there's some sort of link to that. So if people themselves had applied for FAFSA or did so with their children, they seem to be the primary victims of the identity theft. That seems to be where it came from, but it was not from your own systems as an employer. That is not the case. Like I said, the identity theft issue is going to be a big problem, and something that's not yet known are what I call interstate claims, identity theft claims. That is going to probably start appearing maybe in about 6 months from now yet. Interstate claims are a case where somebody may have filed, say, as an example, in Indiana. They filed their claim from Indiana asserting that they had employment with an employer in Michigan. If they did so in March, April, or May, when every single state unemployment system was just in chaos at that stage, a lot of those interstate claims were getting paid out automatically again. And then what happens is that the state then, say in this case Indiana, works with the state of Michigan to resolve that issue. Well, you got one state that's way behind trying to work with another state that's way behind on an interstate claim, and it could be months before the employer is ever even aware that a claim may have been filed in, say, another state that they had no knowledge of, and it could be a fraudulent claim as well. So that is a possibility in 6 months to look at to see if things start popping up in that regard. The agency will not speak to anyone but the victims on identity theft. So even though you as an employer are aware of that fact and you may want to help your folks and might want to help your people, they will not speak to you on it, okay? So they're just not going to do that. There's no way for you to help them. It's unfortunate, I know, because as an employer you want to help your folks, but they're not going to talk to you. So there's no reason to try. And I know, like I said, I know people want to, but they will not speak to you. There are individuals who if they file their claim, especially in May, this is true. There are thousands of people who file legitimate claims in May. There was a time period in May where the unemployment agency simply shut down all the claims because so many fraudulent claims were getting filed. And they basically said all the claims that were getting filed in May and said, oh, we're not going to process any claim until we go through and review the fraudulent aspects of it first. So there could be any number of individuals who legitimately filed the claim in May and they still have nothing going forward because the state is kind of trying to review those things yet. So that is a possibility as well. If you have some people who say they filed in May and haven't seen anything, that could be why. This is related to the question that came up earlier about identity, whether or not the state would send anything to indicate that there was a resolution to the identity theft issue. This is an instance of that. In this case, it's indicating that the individual failed to report or provide the information that the agency was seeking. So it's a case where the agency was trying to contact the claimant or the victim, and they never responded in any way, shape, or form. So if that happens, what the state will do is they give them a period of time. I believe it is a 2-week time period to respond. And if they don't respond at all within the 2-week time period, they then will issue this, which is basically holding what the state is saying is that we're not going to pay anything in unemployment benefits until some sort of information is provided to us about your identity. So in this case, it's a case where the claim is kind of held in abeyance, if you will. The problem is that if this particular victim should, say, in a few weeks actually get laid off and now they have to file an unemployment claim, they have a problem. They have to first resolve this issue, which means that they would then have to actually provide the agency with the information that they're looking for, which is a copies of their driver's license or social security numbers or some sort of identification, before the agency will allow them to open up another claim. So this is a case where victims are sometimes getting victimized twice. First off, they get a false claim filed against them, and then they get on a legitimate claim, they can't actually file it because they have to get the old one resolved first. So if you as an employer receive this and you have an employee, and again it says that you failed to report for the requested information that they were looking for, let your employee know who is the victim so that they will know that that is something that they may have to provide to the agency some information in order to get a clean clearance, if you will, of their account. This is an example of that. It says you reported with the requested documentation. In this case, the person did so to establish that they were. So, but oftentimes there'll be a document that says you responded with the requested information to demonstrate that you were not the individual who filed the claim, and then they cancel the claim. This is what you ultimately really want to do. When I say you, meaning a victim, or what you want to receive as an employer, to show that this clears the account. This will then lead to them canceling the claim, and then if the victim should have to file a real claim themselves later, they'll be able to do it clear without having to go through the other steps. So there's different types of forms that are getting sent out to indicate whether or not there's a problem with the identity verification system. This is another one. You are not eligible for benefits, again, on the identification issue. In this case, because they had, in fact, they failed to report, or in this case, another issue where they had provided the information and showed that they were not, in fact, the person. So this is kind of what you want to get. But if you get the first one, the first identification one that says, hey, you didn't report anything, and therefore your claims, nothing's going to get paid out, that means that nothing's going to get paid out. But if they should have a claim in the future, they're going to have to resolve it. So they might want to take some steps to try to get that reported out. This is a case where you reported with the requested documentation to establish your identity. The individual who reported was not the individual who filed the claim. This is what you want to receive as both the claimant and the employer. If you get this, give it to a copy of it to your employee, because they may or may not get this themselves, because again, the addresses being provided by the criminals weren't necessarily always the correct addresses, so they may or may not get this. So if you do get it as the employer, make a copy of it so at least they will know that this is the kind of the determinations on identification of fraud that you're getting as an employer. This is kind of the gold standard, if you will, on it. So that way at least you'll know that most of the victims are actually getting this, but some don't. So be aware of that. So that kind of covers the identity theft issues. A question: will there be a recording? Oh, I'm sorry. That was yes. I believe there is a recording of the webinar today. I believe, but I will let Tammy kind of answer that more in detail in terms of how that works. Reopen claims. There are two types of reopen claims. If you get them, if you are identified as the separating employer, you do have a right to protest that. And let me see, I hope I have, okay, this is an example. I jumped a couple ahead, but this is an example of a claim renewal where you are the separating employer. You know that by where it says towards the middle of the form, which is the claimant was recently separated with, and it identifies, typically it'll identify a different employer. So if that's the case, if this is I'm sorry, a case where you are a chargeable employer but not the separating employer, unless you're identified as that as a separating employer. So if you get this and it identifies a different employer in that particular little box where it says the claimant was most recently separated with, and it's a different employer name, you do not in that case have a right to protest it. That's simply a notification that charges may start showing up in your account again. This is an example of a claim where you do have a right to protest it because it's identifying you specifically as the employer as being the separating employer. So in that case, you have a right to protest or respond to it. So keep that in mind. Two different kinds of reopen claims. One where you have the right to do it, where you're identified as a separating, and one where you don't have the right to do it. You only have 10 days to respond to a reopen claim, not 30 at all. If you don't respond within 10, they'll consider it to be late, and that may impact your charging to your account. It is possible that you will get as a separating employer, you will get a reopen claim where you have no financial liability because maybe they already had an existing claim, then they were hired with you, and now they separated from you, and you may get this as a reopen claim. You do have to respond to the reopen claim even though you don't have financial liability, because your response at this time will be kept in the agency system as a response to a potential future unemployment claim, maybe 6 months or a year later. So if you're the separating employer, you will want to respond regardless. If you're a base period employer, you don't always have to respond if you don't feel it's necessary. And this is a fact-finding form, something else that you'll be getting for claims. And this, you're going to be getting a lot. You're going to get a lot of fact-finding forms or request for information forms, as the agency will call them. You're going to get a lot of them because the agency is looking for all sorts of information regarding pay information, certification information, able and available for work information. You're going to get a lot of these kind of forms, requests for information forms. What you're also probably finding now is that you're going to be getting a lot of fact-finding forms that are dated today, and for the information for the separation that may have occurred in March or April, and it's going to be a point of confusion for employers. So be aware of when you get the fact-finding forms or the request for information forms, just because you get them today doesn't mean that they're asking the information about, the information they're asking for may not be related towards any separation that has occurred recently, and may be related to a separation that may have occurred in March or April, and they're just getting around to it. So you're going to have to take a look at the form and try to figure out, almost like a puzzle, what they're looking for. Are they looking for a recent separation, or are they looking for an older separation that they might be looking for? If you don't respond to the fact-finding forms, if they're relevant, it could impact your a future claim that's filed in 6 months for a new claim. So again, you may not be a liable employer at this stage. Again, they may have had an established claim. They were receiving unemployment benefits for 6 months. Then they found a job with you, worked for you for 3 months. Now you separated from them, and the agency may be sending you a request for information form about the separation. You have no liability at that stage about the claim, because it's from an claim that they'd already established. But if you don't respond to the request for information form, the agency may, if you don't respond, and then 3 months later the person files another claim for a new claim, the agency may say, hey, you didn't respond to information for the separation 3 months ago, therefore we consider you to be late. So if you get things of this nature, you still have to respond even though you don't have financial liability on it. And the way to kind of determine if that's the case is that the BYB date, the benefit year beginning date, if that, and that'll be in a fact-finding form. I'm going to see if I have one, I hope. Here we go, request for information. You'll note that they will have on here, on a fact-finding form, there's a title that says request for information, employer name, Social Security number, and it has benefit year beginning date. If the benefit year beginning date is before your hire date, that's an indication that you are not a financially liable employer at the moment. But if you don't respond to the request for information now, if this person files a new claim in 3 or 4 months, they may, in fact, the agency say, hey, you didn't respond to this, therefore you're late. So even though you have no financial liability, there are cases where you will still have to respond to the request for information to protect yourself from a future claim, potentially, on it. And since we're kind of here, this is an example. This is a mail date of October in 2020, and it has a benefit year beginning date of March 16th of 2020, which means that the agency, this claim was probably filed sometime in March, and the agency is most likely just now getting around to asking questions about the separation reason for the person at that time. So when you get these, if this particular, and there could be occasions where this person is now back to employment with you. Maybe in September they came back. Maybe they were separated in March. In September you brought them back, and now suddenly you're getting a request for information, and you're finding this to be confusing. Why would they send me this? They're not even separated from us. They're still employed. The reason you're getting it isn't because of the separation that's present, but it could be that you're just getting it now for a separation that occurred in March. So keep that in mind when you get these. And you, as an employer, may have already responded to this with the monetary determination in March, April, and May. You're still going to need to respond to these requests for information because, frankly, a lot of your protests that took place in March, April, and May are probably lost in the agency system. So if you're just getting these requests for information / fact-finding forms, if you're just getting them now and you think to yourself, hey, I've already responded to this back in March, April, and May, they already have that information, don't assume that. Even though you have proof that you sent it to them, even though you provided them all that information, so many things were messed up at the agency in March, April, and May that a lot of those claims and information that you may have sent them is simply lost in their computer system. They were not able to put it correctly to the right claims and claimants, and they may not have that information. So these requests for information are maybe tied to claims that were filed way back when in 6 months ago, 7 months ago. So it's and you're gonna be getting these kind of things all the way probably through at least maybe the second quarter of next year. It would not surprise me to be getting requests for information and claims filed almost a year ago. That would not surprise me at all. Okay, fact-finding, I think that covers that. This is just an example of what a fact-finding form or a request for information form looks like from the back. Again, if you don't wish to provide information, they leave you a box to just simply, hey, we're not going to respond to it. You do have the right to do so on the MyWAM system as well, that you're not choosing not to respond to it. And you do, and again, if these questions are not related to anything that the separation, and you say, well, no, these aren't the right questions, if you go into the MyWAM system, there is a way to change that, and I will show that to you shortly. You're going to get a lot of these kind of requests for information about payment information, and they're just going to start, they're just now starting to come through in October and November. They're just starting to flow through now. The agency, people will have received maybe bonus payments. They may have received vacation pay at some time during a period when they were unemployed, and they are just now getting around to trying to validate some of that information. So expect a lot of these kind of documents to be coming through to you shortly. Again, and responding to these fact-finding forms on MyWAM, again, they're designed, MyWAM is designed to have as little human contact as possible, and is designed to try to have employers and claimants respond in a way that the agency wants you to respond, but that doesn't mean that's the correct way to respond. So be prepared if on the fact-finding forms they have your responses limited. They don't have a lot of, it's kind of a lot of times a yes or no thing. You do have a right to include additional attachments and information, and that's what we really recommend is attach, if you're going to respond via MyWAM, respond with a little more detailed responses than what they might have in the fact-finding form and attach them to that. That would be really important. They do have confirmation numbers to show that they have been submitted. I would recommend that you keep those confirmation numbers because it is not unusual, especially in the last few months where they, meaning the agency, have lost responses by MyWAM as well. That has occurred. So keep those confirmations in case they say you have not responded. This is an example of a MyWAM, a non-monetary, it's called a non-monetary fact-finding form. And it's a question, and here, do you wish to respond, yes or no? If you want to respond, then you do so and you follow it. You'll see that there is a line, and it's towards, and I know this is a small look to it, but if you get to this particular document, there's a line that says change fact-finding, and it's about 2/3 of the way down. It says change issue or change fact-finding. That's where you have the opportunity to say, no, none of these questions that they have asked are relevant to the actual separation, and you have the opportunity to click on that, and it'll give you another set of questions that are relevant. That's where you get to change it on the system when you respond to them. For an unemployment claim, contesting a claim, you need to provide as much documentation as you can, especially if there are written warnings and a termination form. They are really, really important when responding to them if there is a separation in that regard. Copies of the policies that they violated would be important. I cannot emphasize the termination form itself is really critical if you have some sort of written termination form. It really helps the agency in terms of looking at the protest in a bigger picture, and it's really important to include that. If you're especially doing MyWAM, you're going to have to again do an attachment, or you can just include it by fax. Either way, but make sure you include the termination form and any written warnings on if you're going to contest a claim. Any protest that you do make, you do not need to write a book or even a chapter. Anything more than a couple of paragraphs, frankly, is likely not to be reviewed by the agency. The agency, when they look at it, everything that is submitted to the agency, whether it's by a fax and written form or by MyWAM, everything appears to them on a computer screen. And for them to have too much information requires them to click multiple buttons to keep going up and down on the screen, and that doesn't work really well for them to help make decisions. So you'll want to keep your protest reasonable in length so that it would appear on one page. So anything more than 2 or 3 paragraphs is going to be way too much. They're not likely to look through it, and it's a lot of the extra time that you're investing. So 2 or 3 paragraphs, and just keep all the necessary facts. The attachments will be key. At this time, you can provide written statements of others who may have been part of the discharge process. You can't include written statements for others at an unemployment hearing, but at this level you can, so you can do that. If you're contesting claims, make sure that you are giving them the dates of absences and tardies and that sort of thing. And provide facts, not your opinions or conclusions, meaning, on this particular date, Jim did A, B, and C. Not that on this particular date, Jim was, he was horsing around or something of that nature. Horsing around is not going to get it. So you need to explain to them in detail what it is that they did, not your opinion in terms of what you think that they did. If they voluntarily quit and provide some sort of written resignation, provide that to the agency if at all possible. In today's day and age, that means texting messages, email messages, an interview if they have it, that would be great. But something that in writing would be helpful on voluntary quit issues. and in protesting document any claims, you want to avoid certain phrases: poor performance, lack of work, poor attitude, not a team player, difficult to work with, personality conflict. These are kind of words that if you use, you're not going to get a result if you're protesting the claim that you want. They are not fact-driven. These are opinions, if you will, and that they're not going to be helpful. So you want to kind of avoid those phrases. And if you ever use the word discharge for at-will employment, that is almost certainly going to lead to the individual receiving unemployment benefits. If somebody, a claims examiner at the agency, sees at-will employment as far as the reason for separation, that's just a buzzword for them to say that means they're entitled to receive benefits. So unless that is the actual reason, if the only reason why you're letting them go is for at-will employment, that's okay to use it in that case. But if it's for a policy violation or something else, that is not something you want to use as a word to protest for to the unemployment agency. For lack of work claims, and again, we had a question earlier about whether or not you want to protest or not on some of these. We had, for employers, we were recommending, especially March, April, and May, to do so, even though you don't have to if it's a lack of work claim. The rule of the agency, at least the rule that they're supposed to be operating under, is that if the employer does not respond within 10 days, they would consider that to be a non-response and they can issue a determination based off of that. But they're supposed to wait 10 days. So even if an employee was filing for unemployment benefits for a lack of work, unless the employer responded that there was a lack of work, the agency is supposed to wait 10 days. And at that stage, if the employer doesn't respond, they will issue a determination granting unemployment benefits based off of what the claimant said. But what we were recommending for employers at that stage in March, April, May, and June was to respond if you're the employer, so the agency would not have to delay potentially paying individuals because they could match up a lack of work assertion by the claimant, and they would have evidence from the employer showing that it was lack of work as well. They could match that up and say, okay, we can pay this claim without any delay. It was meant to try to help employers at that stage and claimants to get their claims processed faster. Again, you don't have to. It is not a requirement on a lack of work claim that you respond. You can also respond by just simply you're not contesting. There's on the request for information forms and such, you can say you're not contesting the claim as well. Just kind of do that, and that will achieve the same objective. So you don't have to, though we were responding, and we continue to do so in order to try to make sure that they can match it up, but you don't have to. There is, when the COVID situation first hit in March, April, and May, there was a big push by the state of Michigan to identify separations as being a furlough instead of a layoff or a temporary shutdown. There were specific reasons for that, having to do with federal payment of benefits and that. But at this stage of the game, there really, from an unemployment standpoint, there really isn't a distinction or difference between furlough and layoff. There was a push to do so back in March and April because there was a distinction in federal payments based off of that. That was important, that the state was trying to make sure employers were able to get that covered. But that's no longer the case. Things have changed. So if the question comes up, well, what's the difference between a furlough and a layoff? Furloughs, generally speaking, are considered situations where, as an employer, may let somebody go but are continuing to pay their health care benefits, and there's an expectation that they're coming back. A layoff, generally speaking, is that they are not expected to come back and that the employer is not continuing to pay anything such as health care benefits or anything of that nature. That's kind of the general distinction. But from an unemployment standpoint, furlough and layoff really, it doesn't really alter how to respond to the claim. Furlough and a layoff is considered the same. The agency layoff, we would recommend just a layoff at this stage of the game. Furlough may create some points of confusion now, but originally that's the way the agency wanted people to respond. in March and April and May. As I said earlier, be prepared to provide information on vacation and holiday payouts and severance information. That you're going to get a lot of fact-finding and or request for information forms on this. If you don't respond, it may delay payment for some individuals a little bit. Again, you don't necessarily have to if you don't want to. Depending on how many you get, that may be a problem, investing that kind of time, but it may simply delay the amount in which individuals may, when they get their unemployment benefits, if you don't, kind of thing. If hours have been reduced, if you have somebody who is receiving underemployment benefits and their hours have been reduced and then they were reduced and now they have been increased back, let the agency know that fact. So in other words, maybe there was a time when they were working 40 hours and you reduced it to 30 and now they're back up to 40. You want to let the agency know that fact, because that may eliminate future charges to your benefits. If they're back to working full-time for you, that may mean that you no longer have to pay underemployment benefits and that sort of thing. So report that if that should be the case. And at the time that, if you're reporting that somebody is laid off and there's an expected return to work date, at the time that you respond, inform the agency of that fact as well. This is just an example of a notice of a determination of these are the kinds of things that you're going to be getting a lot of. File things, in this case, the issue is a filing issue, and where you know where the what the issue is, it's going to be, there's a little category there that says issue. It's where and big headlines it says notice of determination and has BYB, case number, claimant, employer, and there's an issue. Things such as filing are not issues that employers would typically see. Same thing with registration, same thing with able and available, certification, reporting issues. Normally you would not see these kind of determinations coming across your desk where the issues are identified at that. Generally speaking, most employers would only see issues where they say voluntary quit, layoff, or discharge. But you're going to be seeing a lot of determinations showing things like filing, reporting, registration. Those kind of issues are going to be popping up a lot on the determinations you get. For a lot of them, you don't have to do anything. Like this is a case of a filing issue. This is an issue between the claimant and the agency. So you as an employer don't really have anything to respond to. So be aware that not every determination you have to respond to. You want to look at where it says an issue. The issue is a voluntary quit, discharge, or layoff. That is, or a failure to accept employment. Those are the kind of issues you'll want to respond to. But if it's one where it says filing, reporting, certification, those are issues that are just really between the claimant and the agency. Normally you wouldn't get them. But because of the circumstances of COVID, you're going to get lots of these kind of determinations. So be aware of that. I did also want to kind of point out that the agency rules and regulations are constantly flying around, and so there are a lot of changes. In this case, it indicates that an individual filed on November 2nd of 2020 and for their unemployment benefits, which is beyond the 28-day period to establish good cause. They were filing their claim in November for benefits in March. So you're going to get people filing even benefits now, trying to get them retroactively applied to that time period. So you're going to see lots of strange things, okay? Be aware that and be ready for that. There's going to be a lot of oddball things coming on. In this case, the individual is not eligible from March 15th to October 31st because of that. But you're going to see a lot of determinations that you normally wouldn't have seen. You don't have to respond to them, or they're not really even relevant to you, but just expect to see a lot of these things. Another example, reporting and certifying, and this is a point that's going to get a little confusing because individuals are not required to seek work at the moment. That is not something that they're not required to do. However, and again, these are kind of the legacy problems in a computer system. there's a 3% of all claimants who file an unemployment claim are required to go through what's called a RISA evaluation, and it's for individuals who are unemployed. They're supposed to provide some information to the Michigan Works about their skill sets, and so that it helps the Michigan Works programs develop programs to allow them to create better programs to employ people. The problem that's happening is that because individuals understand and know, and they're informed by the agency they don't have to seek work, they're getting these requests to participate in these RISA examinations. And so claimants are oftentimes simply ignoring them because, hey, I don't have to seek work anyway, so they ignore them. Well, the computer system is saying just because they have sent it out and they're not receiving a response from their agent, from the claimants, meaning the agency's computer systems are saying, hey, you didn't respond to a request for a RISA examination, therefore we're not going to give you unemployment benefits because we consider you not to be reporting as you should. So you may get cases where people are going to come to you and say, hey, they're saying that I didn't do this or I didn't do that, and I'm not getting my benefits. It could be for a lot of different reasons, and this might be an example of one where it has nothing to do with what you did as an employer. It's the fact that they didn't respond to the request for a RISA examination from the unemployment agency. So it's kind of just because people meaning the claimants, may even have contacted the agency, and the agency may give them a response that they're waiting on information from the employer. This is happening a lot. And so they'll come back to you and say, hey, they're saying they're waiting on information from you as an employer, and there really isn't anything that they're waiting on from you. It's just that they at the agency, these are a lot of untrained people who don't know what they're looking at, see that there is a delay, and one of the delays might be, for instance, this issue. And this is an issue that they haven't been trained in at the agency. They don't know what a RISA, they themselves don't know what that means. And so rather than inform the individual, we don't know why, they're kind of being trained to say things like, well, we're waiting on a response from the employer, and it might be something like this. So there are a lot of reasons why claimants may not be getting their benefits, and it's not tied to you as an employer. Just be aware of that, even though the agency might be saying that that's the case. Another determination about, this is a remuneration issue. This is a case where an underemployment issue. An individual earned more than 1.5 times their weekly benefit amount, and so they're not eligible for unemployment benefits for that particular week because they reported more than 1.5 times their weekly benefit amount. So there are occasions where individuals might be receiving underemployment and then suddenly are cut off, and it might be because of this. It's not something that you did as the employer. It's the fact that they may have reported more than 1.5 times their weekly benefit amount, causing them not to continue to be able to receive underemployment benefits. Again, another remuneration determination. This is a case where for every dollar an individual receives in wages, they're supposed to report them. And for every dollar they report in wages, it reduces their unemployment benefits by 50 cents. And this is a case of them explaining that particular instance. I got a question here saying, so there is no seek work requirement for anyone at this point for regular benefits or during the pandemic. That is correct. Right now there is no seek work requirements. However, claimants will get these requests to participate in the RISA examinations, and if they don't participate in the RISA examinations, then they may end up not getting unemployment benefits for that. The RISA requirements can be answered usually online. I believe they've got them set up in that regard now, but that could cause them to not get benefits. But right now, there is no seek work requirements yet. Another question, I'm getting a lot of requests for information that say the employee refused an offer of work that are completely untrue. The online form does not give you the option to say that this is false. So after faxing in for, you're hearing about other employers having this problem, a lot of requests for information that say the employee refused an offer of work. If I'm understanding the question correctly, you're getting things that indicate that they refused an offer of work when you as the employer didn't actually offer that, is what I'm I'm reading from that. That I have not been. We have not received that that kind of situation. We're receiving a lot of failure to accept an offer of work, but that's usually in response to the fact that we, as the employer, have notified the agency that an offer of work was made and that they had refused it. That is, we're getting a lot of that, but we're not getting situations where they are saying, hey, they refuse an offer of work. Now, it's possible that another employer not tied to you they may have had multiple employers. They may have had 2 or 3 employers, and maybe from you as an employer, they had not received an offer of work, but maybe from one of the other employers that they were employed with, maybe they offered them work and they refused. And so if that's the case, then you may be getting a determination saying, hey, you refused an offer of work and therefore you're not eligible for unemployment benefits going forward. That's possible. So that it may not be tied to you personally as an employer, but it may be tied to another employer, but you're getting the determination informing you of that fact. And again, this is one of the challenges in the COVID era, because employers are getting a lot of these kind of determinations that are explaining circumstances that may not be related to them. That might be, I'm guessing that might be what the question is related to. So that is certainly possible, that you're getting a determination saying they refused an offer of work that you didn't offer, but it may have been somebody else. And so that might be impacting that. I hope that answers the question in that regard. For the pandemic unemployment claims, again, there should be no charges to the employer for any claim that was a pandemic unemployment claim. So if you file a pandemic unemployment claim, there should be no charges to your account at all. It's really between the claimant and the agency. So if somebody is having a problem with filing their pandemic unemployment claim, there really isn't anything that you can do as an employer to help them. The pandemic unemployment claims were primarily for low-wage earners. Maybe they didn't qualify earning $3,744 a week, or maybe, in a quarter, but maybe they were earning $2,000 a quarter from you as an employer. They didn't qualify monetarily, but they did from the pandemic unemployment program. That is between the claimant and the employer, and there's really nothing you can do to help them in that regard. If they filed a pandemic unemployment claim, you're pretty much out of it as an employer. That's really between the claimants and the agency. There's nothing you're going to be able to do to help them if they're having problems on that. For the underemployment issues, and again, an individual must be working fewer hours than what would be considered full-time. Unfortunately, in the state of Michigan, we do not have a defined time period about what is considered full-time. In other words, there's nothing in the law that says full-time is 40 hours or 36 or 32 hours. That doesn't exist. So full-time is a little bit of a challenge to describe, but full-time in generic terms in Michigan is what has been agreed upon between the employer and the claimant as to what's considered full-time. So if the employer says, hey, it's 32 hours and we consider that to be a full-time job, then that's what it would be in the state of Michigan. If a claimant earns 1.5 times the weekly benefit amount, then the claimants aren't eligible for anything in unemployment benefits. So maybe they went from 40 hours to 32 hours, and they qualified and that for the maximum amount of $362 a week in unemployment benefits. However, if that 4 days a week that individual is working, and they earn more than 1.5 times $362, which I used to remember that off the top of my head. I think it's $544. If they earn more than, $543. It's right there, $543. If they earn more than $543 a week in that 4-day time period, they're not going to be eligible for underemployment benefits at all. So anything more than 1.5 times their weekly benefit amount, if they earn more than that, either between you or another employer, they're not going to be eligible for that. And that's based off of all their jobs. So if they have multiple jobs and they're earning, maybe they've been reduced in hours from you, but they have another job, it's the combination of wages between multiple employers that determines that. They have to report their gross wages when they are certifying for benefits, not their net wages. And every dollar they report reduces it by 50 cents. Briefly, the work-share program, which became immensely popular during the this era, has been changed, and I want to briefly kind of go over that. A reduction in between 10 and 60% of work hours is now considered acceptable and still allow yourself to be a part of the work-share program. That has been expanded immensely. It used to be much less than that. So for the moment, that still stays in place. So if you're an employer who has reduced hours by 60% amongst your employees, you can potentially look through the work-share program. But there are a lot of challenges to the work-share that may not work for you as an employer. A question: we have employees who have been on work-share since April. If they are eventually laid off, how does the money they receive through work-share affect their 26 weeks of employment? Will they receive less than 26 weeks of unemployment? And the answer to that is yes. If they received a week of, well, let's say if they were since April, let's see, May, June, July, August, September, October, that would mean that by this time, if they are now laid off going forward, they will have used up their 26 weeks of regular unemployment benefits. However, because of the extended unemployment benefits, they would still not then be eligible to receive extended unemployment benefits for 13 weeks through the federal program and then 20 weeks for the state. So that should still get them to the 52-week time period before they would have to file another unemployment claim and then get 26 weeks of regular unemployment benefits as well. So yes, for every week that is reported under the work-share program, and they receive, $50 or $60 or whatever it is from the work-share program, that counts as 1 week used up for unemployment purposes. So if they receive 26 weeks of work-share unemployment, that would eliminate their regular unemployment benefits, but they are eligible for 13 weeks of extended and 20 weeks of state extended yet. So that should cover that as well. It's one of the, and it is one of the things on a work-share program that was not necessarily covered well about how that might impact. The whole idea of a work-share program was to try to eliminate anyone from getting laid off during a time period. No one had the expectation that COVID was this issue was going to continue for 6 months or longer, or at least no one was hoping for that, I should say. Unfortunately, it has. So now it's created a circumstance where, okay, now we've used up 26 weeks. What are we going to do? Fortunately, there is the extended benefit program in those cases, so they can still collect benefits at the full amount of $362 a week for that time period, should it be the case. For work-share programs, it works for employers that have set hours. So that if you have employees that have regularly work 40 hours a week, for instance, and you have a specific number of employees in a department that has a reduction, rather than lay someone off, it allows you to reduce everyone's hours in that particular department by, say, 20%, and therefore you don't have to lay anybody off. Individuals then would be able to get 20% of what their normal weekly benefit amount would be for the week, and collect for 80% of their regular wages. And it works well if you have set number of hours. It doesn't work quite as well for employers who have employers whose hours fluctuate from week to week. In 1 week they work 40, 1 week they work 24, 32. That doesn't work well for work-share programs. So keep that in mind if that's something you wanted to consider in it. Employers certify for the employees with work-share programs, so it's a little easier for the employees in that context. But the employees still need to open up their own MyWAM accounts. Also, and this is going to be a challenge going forward, is that employees are supposed to report any additional wages they may have had with other employers to the employer who's using the work-share program. My best guess is that was not happening in a lot of cases, and a lot of people may have had wages that they were earning with other employers, and if they didn't report those wages when they were certifying, something tells me that about 6 to 8, 9 months from now, they may be getting a statement from the agency saying, hey, they might owe money back because they didn't report those particular wages. So if an employee who you are certifying for does not report to you wages they earn with another employer, they may get a bill later on from the agencies if that should occur. So be aware of that. I'm going to get a lot of these failure to accept issues. A lot of employers are having some problems getting people to return to work for them after they have been let go. In order to be able to contest any further unemployment benefits in that case, the employer has to be able to show and demonstrate the offer was known to the employee in writing. So if you're just contacting them by phone, it's not going to be enough. You need to put it in writing in some way so you can provide that to the agency, showing here's what the offer was in writing and that it was given to them in writing in some way. You also, as an employer, are going to have to demonstrate that you meet all the state safety requirements for COVID-19 protocols. So a lot of the failure to accept issues are related to that we have been noticing, is that employees are saying that the employer was not meeting, they didn't feel safe going into the employer's work environment. And if the issue is just that and the employer doesn't come back and can't demonstrate in some written form that says, no, we are following all the safety protocols, that could lead to an issue of you not being able to contest the fact that somebody is refused an offer of work and is still going to collect unemployment benefits. Question: if an employee is on layoff due to the pandemic and are called back to work to do a different job, can they refuse to work and still collect unemployment benefits? That is a possibility. Absolutely, yes. It's going to depend on the work that was offered. If it's within the realm of their capabilities, then if they refuse that work, that could be a reason for denial. But for instance, if it's somebody who is working in an office environment and the job offer was for something that's in a manufacturing or production environment, then they're going to have a good reason to refuse that particular job. If it's something that's not within their skill set, maybe it's a job that they were working in purchasing, as an example, or in HR, and now you have a job open in finance, that might be a problem as well. So it's going to depend on their skill set. If it's a job that they have the skills to do and it's within the realm of like an office job to an office job kind of thing, then in those cases you'd have a good chance of being able to show that the refusal of the work was not with good cause. But if it's not within the realm of their skill set, or if it's in a different type of an area, then they were going to have a right to be able to refuse the job. Question is, why do we receive failure to accept fact findings stating that we, the employer, reported a failure to accept when we didn't report that? And again, there's a couple of logical explanations. Is that an issue of a failure to accept issue may have been generated from another employer, not you, but another employer. And the way the agency system is working right now is they're simply generating that to all the employers on the claim. So if maybe they had multiple employers, and one of them is saying, hey, we tried to call them back and they refused, the agency is going to automatically send that out and say, hey, the employer made an offer of work and you failed to accept it. It may not be related to you as the employer, but to another employer. But the agency is not making that distinction in the fact-finding forms and the determinations they're issuing. So that's one of the reasons that might be happening. One other issue that's really important is that claimants are required under the law to keep an employer who has laid them off informed of any changes of their phone or address, so that if you are trying to get somebody to come back and the phone number that they left you last when they were laid off isn't working, and you're trying to get back with them and the address doesn't seem to be working, under the law, they are supposed to have kept you informed of that if they were laid off. If they fail to do that, it is something that you can notify the agency about and say, hey, we're trying to get these folks back, but the phone number they provided is no longer valid, that's something the agency will investigate. It's going to take time, but it is something the agency can investigate and look at. This is just an example of a determination but a failure to accept. The work was not suitable under, in this case, they failed to accept. You refused an offer of suitable work in July because there was a risk to your health, safety, or morals. And generally speaking, what these determinations are coming out is it's related to them saying, hey, I don't feel safe because of COVID at my employer's place of employment, and that's why I refused the offer of work. And that's why it then becomes the burden shifts to you as the employer to show that you are meeting the guidelines by the state for that particular type of business that you're in. And again, they're going to be a little bit different for every business. But if you did offer work and you are meeting all the guidelines and such, then it is something that you can protest under that scenario. But if you are not meeting the standards that the state has, they have a right to refuse that job at this stage and continue to collect unemployment benefits. And this is an example of that. Another failing to accept the issues, you failed to accept your refusing offer of suitable work on May because the position available was not the same or similar to position you previously performed. The work was not suitable. So this is an example of a question that we came up a little bit earlier. So the job has to be similar both in wage and hours, and it has to be similar in terms of their skill set. It doesn't have to be exact, but it does have to be similar. And if it's not, they will have a right to refuse that in today's environment. Voluntary quit issues, the burden is on the claimants to demonstrate they had good cause to quit. And specifically, these are the types of reasons why someone can quit and collect benefits. Medical conditions, spousal, military exceptions, suitable work issues. Rules regarding COVID, again, if you as an employer are not following state guidelines, that will be considered good cause for somebody to quit and collect unemployment benefits. So that is something that's a little different now. Question, what if you have someone who had an injury occur while on layoff that required surgery and wasn't able to return to work on the offered date? Now that becomes an able and available issue. Because of their medical condition is not COVID related, they are not able and available for work. And if you're not able and available for work, you are not eligible to receive unemployment benefits. So if they're not able to work because they sustained an injury or have a medical condition while they're on layoff that does not allow them to return to work, they're not eligible for unemployment benefits even now, unless the issue is related to COVID. An individual does not have to seek work at the moment under the rules that we have right now in the state of Michigan, but they still have to maintain the fact that they're able and available for full-time work. And the case in this instance is that they are not able and available if they have a medical condition preventing them that's not COVID related to returning, so they would not be eligible in that particular circumstance. This is just a determination of a voluntary quit that we're beginning to see a lot coming on here. You quit your job in January due to a risk to your health, safety, and or morals. You are, in this case, they're disqualified because your employer had measures in place to ensure your safety at work. So this is an example that I had spoken about a little bit earlier, where if you as an employer, somebody quits and says, hey, I don't feel safe here, but you can show and demonstrate to the agency you're following the state guidelines, and they quit, they may not be eligible for unemployment benefits for quitting. But you as the employer will have to respond to that, to demonstrate to the agency that you're following state guidelines. Also note that this is a determination, in this case, that was mailed in November for a claim that was originally in May, and the issue itself took place in January. So it's taken the agency a long time to respond to these things. Question, if we have part-time or full-time work available for a couple of weeks due to busy times, can an employee that has been laid off refuse to come to work if we call them? It is not a full-time offer, it's just for a couple of weeks. And the answer to that is yes, they can refuse. Claimants only have to be able and available for full-time work. They don't have to be able and available for part-time work or just short-term work kind of thing. So they would have a right in that case under the state of Michigan laws to refuse that if the job is only for a week or two. Their claim can be, I'm looking for work and I need to be able to work, have the time to look for full-time work, and if I'm working part-time, or not part-time, but even full-time for a week or two, I can't do that. So unless the job is for a full-time position, permanent full-time position, they will have a right to refuse that particular job in that circumstance and collect unemployment benefits. This is just, again, a notice of a determination on you failed to, this is an issue related to COVID as well, where people may be saying, hey, I can't continue to work because I have a COVID-related issue. It is appropriate and okay for the employer to request that the claimant provide some sort of medical documentation regarding that. And if the claimants or employees refuse to do that or don't do that, they may not be eligible for unemployment benefits. So just for an assertion, somebody to assert the fact that they are not able to work due to COVID-related issues isn't necessarily enough. They have to be able to provide some sort of medical evidence of that fact now. That wasn't the case originally, but it is now. So that if an individual doesn't provide some sort of medical documentation showing that they have an immune issue or have some sort of issues that related to that, and then that's why they can't continue to work, they need to provide medical evidence to you as an employer. If they don't, they may not be eligible potentially for unemployment benefits. Question, if the notice states redetermination, does the employer need to respond? Again, you don't necessarily, if it's a redetermination as an employer, the choice to respond or not is up to you in just about anything as it relates to the agency. If it's an issue that's not related, if it's an issue of a redetermination that you disagree with, yes. If it's an issue that you just don't disagree with or you don't want to take forward, no, you don't have to. So if it's something that doesn't concern you, or it's an issue that you don't want to take to the next level, no, you don't have to respond to that. I'm going to kind of zip over this a little bit, so I want to get to a couple other things on this, so we have enough time here. For voluntary quit issues, if you have a system in place allowing an employee to voice complaints, that's a really key element, especially in the era of COVID. Important to do so. If they are saying, hey, you guys are not following the proper processes and procedures, they have to still let you know as an employer to give you an opportunity to correct that. If they don't do that, they're quitting, saying, hey, they weren't following proper process and procedures of the state isn't going to be sufficient enough. They have to let you as an employer know that ahead of time. So that's something that's important to do, is have a system in place allowing an employee to voice their complaints. For discharges, questions, and again, this is real kind of in generic, you have to establish as an employer that there's a policy. You have to establish the employee knew the policy, that the employee violated the policy, and that the claimant was informed and discharged for violating the policy. And it's the last one that's really key. A lot of employers will sometimes say they are discharging someone and they don't tell them the reason why. They just say, you know, it's not working out and we're letting you go. If you do that, the employee is probably going to collect unemployment benefits. It's really important that you give them the detailed explanation as to why it is, if you're discharging them, as to the reason why. And again, on discharges, if it isn't written down, it didn't happen. So the fact that you verbally warned somebody is not relevant. The agency doesn't consider that to be a written warning for disciplinary measures in cases of discharges and that sort of thing. Attendance issues are much more of a challenge right now in COVID as well. again, you might have an attendance policy, but because of the fact that so many people might have been exposed as it relates to quarantining, as it relates to child care issues, the attendance policies that you presently have in place may not be operative or work well in terms of unemployment processes. So even though you might have a point system, and if somebody says, hey, I had child care issues because my kids were in-person learning, and now they're suddenly notified they're having to be at home, that could be a good cause for them not to be attending work. So be aware that your present attendance systems under the COVID era may not work as well as it normally did prior to COVID, because there are a lot of changes going on. So people have a lot of different issues. So if you have a point system here in the COVID era, it probably isn't going to work very well to deny people unemployment benefits if they violate the attendance issues. Leave of absences. Again, the Families First Coronavirus Response Act does allow provisions for employers who are between 50 and 500 employees that they have to provide leaves of absences for people for COVID-related issues, and so hopefully most employers who are in that circumstance already know that. But if you didn't, if an employee does file for a leave of absence because of a COVID-related issue, you now, under the Families First Coronavirus Response Act, have to provide them some sort of leave of absence as it relates to that. And then able and available issues, again, they have to be able and available even during COVID for full-time work. If they state that they aren't able and available for full-time work, they might be ruled ineligible. Child care issues are not defined during COVID-19, but that means what we have been seeing is that agency people, individuals who are saying that the reason they can't be able and available is because they have child care issues as it relates to school sort of issues. There's no consistent decision-making responsibility, or there's nothing consistent at the agency regarding this issue right now. So in some cases, they are allowing unemployment benefits to individuals who are stating that they're not able and available because of child care issues. In other cases, they're denying it. So I'm not comfortable in saying that that's a fair issue or not, because the agency itself is not issuing a consistent message on this. Sometimes they're allowing benefits, sometimes they aren't. So if somebody comes and says that they can't work because of their child care issues during COVID, I cannot tell you whether or not that's going to allow them benefits or not. This is an example of that. You've not resolved your child care issues. You do not meet the availability requirements of the Act. This was issued on November 5th, but on November 4th, it says, based on the information, you do show that you have child care issues. You're still not ineligible. So here's a case where the agency is saying, hey, you had child care issues, you're being denied. You having child care issues, you're being allowed benefits. So I can't tell you for sure about child care issues because the agency is not providing a consistent message on that. On availability, you have not provided evidence from your school or training to establish that you rearranged your classes in order to meet the requirement of being able and available. That just goes to demonstrate the fact that people still have to be able and available for full-time work, even though they don't have to necessarily seek that work out at this stage. Again, about availability, a demonstration, your home address, email address, and telephone number have changed since you filed your claim. You did not report that to your you do not update this information to the unemployment agency. You do not meet the availability requirements of the Act. Employees have to do that, both to the employer and to the agency. And as far as ability, evidence has been provided to establish that during your illness or injury restrictions, you were able to perform full-time work. You do not meet the ability requirements. Again, this is a case where somebody may have had an injury, as we had earlier questioned, not related to COVID, and allow them to receive unemployment benefits. A question: when filing a payment protest online, you're forced to select a reason. If protesting a non-chargeable payment, none of these reasons apply. What would you suggest we select? I've used ability in the past just because it doesn't require further input. If it's a non-chargeable payment, in other words, if your account is not being, and I hope I'm understanding the question correctly, if you're showing that there is a payment but you're not being charged for it, then no, you really don't have any ability from the agency standpoint to protest payment of benefits. Again, there's a difference between an individual being allowed benefits and whether or not your account will be charged. If your account is not being charged, you don't really have that right to protest the fact that they're receiving benefits, maybe just not chargeable to your account. I hope I'm understanding that question correctly. I'm filing a payment protest, a non-chargeable payment. I may not be understanding that question correctly, but if it's a payment is a charge issue, unless you're being charged, the agency will not respond to your protesting if you're not being charged as an employer. It'll only respond to it if you're potentially being charged as the employer. And this is the one thing I did want to kind of get into. You're going to get a lot of these showing there are weeks of overpayment. These are cases where people were paid unemployment benefits and the agency is now saying no, they shouldn't have been. These should ultimately lead to you getting credits to your account, but it may not. So keep these in. If your account was credited from this amount, then you're okay. If it wasn't, and you show charges on it, keep this as a record to be able to show that you are protesting and you have evidence of that. Of course, this I'm being charged should be non-chargeable. In that case, then the question was a response earlier, I'm presently being charged for benefits, even though the agency said that they should be non-chargeable. If the benefits are being charged to your account, then you need to protest the weekly charge statements. If the agency does not allow that on the MyWAM system, and again, they're not really geared towards that, the only really way to do that then would be to protest it by a fax and written document. That's really the only way to do that in that particular case, if it's that circumstance. I want to go and zip by a couple of these about the charging process, and this is something I really need to let everyone kind of know. This is an example of a weekly charge statement, and on it you'll see that you're getting charges and credits from March, April, May, June, July, all the way through October. So you're going to be getting, this is the one that was issued in November, and you're going to be getting charges on your weekly charges showing credits and charges to your account all the way from March through, again, October. This is going to be going on through the rest of the year and through next year. You're going to be seeing a lot of these charges, credits, back and forth. You're going to have to spend a lot of time reviewing your weekly charges statements to make sure that the charges are being credited when they should be and that they were issued. This is a case of it showing that there are some credits, there are some charges, and it's just going to be an ongoing battle. This is going to be a statement that you're really going to have to spend a lot of time working with, dealing with as an employer at this stage, because the agency is charging and crediting, I don't want to say randomly, but a lot of benefits are getting charged that should not be getting charged to your account, and this is the mechanism for you to be able to determine that and protest, and this is what you'll have to protest from. It does show claimant reported earnings, so if individuals are reporting earnings and then they're from you, you can validate that fact to determine whether they're correctly reporting them or not. And this is a mechanism to do it off of the back of that particular document. This is the quarterly charge statement, and you'll note that in a quarterly charge statement, you don't have the right to protest the quarterly charge statements, but you do have, this is a good overview, if you will, of what has happened. You'll note that in this particular circumstance, it's showing that there are charges to the account, there are credits to the account, and then there are also ones that are showing that there is $0.00. What we are recognizing is that they may be tied, the ones that show $0.00 may be tied to the fact that the agency credited your account but did not provide you evidence of that fact on the weekly charge statements. And this might be something for you to look at. The agency has not verified or validated that with us yet, but from what we have recognized, we believe that anything that's showing up on your quarterly charges at $0.00 means that you were charged at one time, but the agency has now credited it, though they haven't necessarily shown you as being credited on your charge statements. So keep that in mind when you're trying to determine what you should be legitimately charged for and not, that may be an indication that you were actually credited internally, but not notified by that by the agency. That kind of wraps up. I wasn't sure. I kept the thing about administrative law judge hearings in case we had extra time, and we really kind of reached our time limit here. So I'm going to kind of pass on the administrative law judge hearings, but I did want to note that for judge hearings, you're going to get a lot of them. A couple things to let you know for the hearings. A lot of these hearings are not going to be related to something that you're going to have to participate in. A lot of them are going to be related to the claimants having issues about reporting certification issues. You're going to simply want to look at real quickly where it says on here for notice of a phone hearing, it'll have issues to be considered. Unless it's a 29-1A or 29-1B issue, generally speaking, most of the other issues are not going to involve most employers, and you won't necessarily have to participate in them unless they are that. So keep an eye on where it says what the issues are to be considered. If they are 29-1A or 29-1B, you're likely not going to have to participate in them. They should have statements like this showing that employers don't have to participate. Also keep in mind that the state of Michigan and the problems that we're having with the Postal Service, the hearing notices are always sent out by the U.S. Postal Service. They're not sent out by electronic means at all. And there are a lot of problems with the Postal Service getting these issued out in a timely manner. So if you get a hearing notice and you have not been notified of that hearing notice within 10 days prior to the hearing, you have a right to get the hearing postponed. So I did want to include that little issue on there because a lot of employers are getting hearing notices with only 1 or 2 days before the hearings are set to begin, and it's a challenge to do it. So if you do get something that's late in receiving in a mail and a hearing notice because of the Postal Service delays, you have a right to seek a postponement of the hearing and give you proper 10 days notice. So that real quickly kind of covers up the main issue that I wanted to cover on administrative law judge hearings. But otherwise, it covers kind of the gist of the issues here related to COVID. If you have other questions or whatever, I think there's my email is included in there. Please feel free to send me a question to me via email. I'll be happy to try to answer anything that you might have. If you're part of it, just mention the fact that you were part of the Michigan Chamber of Commerce seminar. Please do that because if it's not mentioned in that, it may get delayed from me being able to respond to it. But mention that you were part of the Chamber seminar and in the emails that you have sent to me personally, and I'll be happy to try to answer something that may not have been covered here at the hearing. My email, it's at the very beginning, but let me give it to you right now. It is at B as in Brian, GMERICK at FARMGT.com. And I believe it should be on the second or third screen on the webinar here document. The email should be there, but if not, that's what it is. And if you have other questions, feel free to give me a call. Send me an email on that, and I'll see what I can do. Otherwise, I thank you for your time, and that's all that I have for the moment. Thank you.
Great. Thank you, Brian, for your time, and thank you to the audience for the great participation and questions. The handout, survey, and certificate are now available on the website, and the recording will be available shortly. For upcoming webinars, please go to webinars.michamber.com. Today's program is copyright 2020 by the Michigan Chamber of Commerce with all rights reserved. Have a wonderful day. You may now disconnect.